across this nation. It's a great day in our history, and you're all a part of it. So God bless you, and God bless America, and God bless America.
Thank you. Wow, you made my day. Where are you guys from?
I'm from Texas with the Petitioner.
Okay.
I'm on the women's.
Awesome.
And you just came to
Okay, no way!
here
Oh my God, we should have had you speak. Sam, you're
brilliant.
I'm trying to keep up with you, ladies. Listen to this woman.
Yes, I competed against a biological male last year. My senior year of high school. Oregon. Not surprising, though, but you know that's why we're here to try to make change. This isn't going to be the end goal. This is just incredible athlete here in sport. I am in college at the University of South Alabama right now. I graduated from high school last year, and then like to support the cause, so I started moving last year. Yes, I do track and field in college. No, the NCAA has been a lot better. They have actually put protections on women's sports that we unfortunately don't have yet. So we have spoilers, but kind of getting to
Tennessee. Okay, ready? I'm gonna. Hi, I'm here with Alyssa Anderson and her mom right here, and we are in front, as you can see, of the Supreme Court.
I guess the longer I take, the more you can hug. Thank you, brother. How you doing? Thank you. Thank you. Yeah, I'm going to just do it. One, two, three. Ready? One, two, three. And last one, I promise. One, two, three.
I said that.
I'm a reporter with Kensington, and so you guys will want to chat with the camera. Did anyone want to do a quick quick interview?
That's about what you believe in?
It's not live, it's just recorded, and I'm just... Oh, it's okay. That was really cool. Somewhere. Here?
Yes. I mean, that's your call. That is not a me call.
I'm sure there's a couple of customers.
Thank you. Thank you. I'm Brad. Okay, we'll do. Thank you so much.
I know, and I thought about it on
What you can do with your reproductive rights? No. Are trans people the ones that are denying maternity leave? No. Are trans people forcing women to go back into the homes? No. Did trans people fight against women's right to vote? No. So why are trans people the people that are fighting against women's rights when we're not? We are actually for this because we believe that women have the right to do with their own bodies. And everyone's saying protect women. What about men's sports? You know? Everyone's feeling like sports rights. Well, sports is a privilege. So, you know?
I can bring it on the plate.
That's so cool.
Yeah.
And I tried my best.
Oh, I don't know if I can do it right now.
Exactly. Oh yeah. But here's
Thank you.
that wasn't happening.
On that one
bear. I don't think you need that.
And he sent me a couple pictures of it.
Boy, my God, he's a senior. He can ride an effing scooter, but...
I recognize the
under all laws, legal and binding, under penalty of perjury, that you will not interrupt me till I finish my sentence. Is that clear? Do you promise under... You promise under all laws, legal and binding, under penalty of perjury, that you will not interrupt me until I am finished?
I'm from the UK, but I'll let you speak. I'm off the speaking.
Okay, how can you be pro the Matrix and anti-trans at the same time?
I'm on the edge of the Matrix. I think there was Chelsea Gilmore.
Gonna burn this goddamn house right down.
The history of the movie. Trans didn't even exist when they wrote the movie.
You're saying trans people didn't exist when they wrote the movie?
I'm saying there's no such thing as trans. Unless you can define it for me. Define transgender.
Not identifying as the sex of birth. Is your Google broken?
Not identifying as the sex of birth. Is that what you said?
Is your Google broken?
Is my Google broken? I'm asking you. I want your thoughts, your mind.
Or are you asking for the factual answer, or are you asking for my opinion?
No, I want what you think of your opinion.
Well, if the opinion varies, does it matter?
You don't have to.
Well, then why is the point of asking my opinion if you know it's different than mine?
I'm interested in what you have to say, because I believe that you're a man identifying as a woman, okay, which is fine. There's nothing wrong with that at all, as long as you don't invade women's spaces.
Okay, can I ask you a question then?
Yeah, of course.
How would you feel of a trans man with a huge beard going into a women's room? Would you feel fine with that?
A trans man's a woman.
Yeah, but if you just see that person with a huge beard going into a women's room, how would you react? You don't know that person is trans. You just see that trans man with the beard. How would you react?
Well, this is all about safety for women. As a man, I'm not afraid of women, okay? But women are afraid of men, and this is about men in women's spaces.
Women are afraid of men? No. Oh, that sounds pretty sexist of you. Anyway, can I ask you a few questions, and you must promise under all laws, legal and binding, under penalty of perjury, you will not interrupt. If you interrupt, then this interview is over. Is that clear?
I'm not going to promise anything.
Well, then this interview is already over if you do not promise under all laws, legal and binding, under penalty of perjury, that you will not interrupt me.
I can't promise that.
Well, then the interview is over.
I'll let you speak.
You have to promise you won't interrupt. If you interrupt, the conversation is over. Is that clear?
Do I get a chance to come back to you?
You can come back to me after I am finished. If you refuse to let me finish,
I'll go with that.
a barrier. You can go right up and.
Fantastic. Okay, thank you.
That's good to know. Yes, a little longer up.
Thank you so much.
The organizers said that. Are they going to speak later at the podium?
No. Okay. Yeah, I was going to pick up points and then.
I probably will be there. I'll look for you guys. Thank you. Sorry.
Okay, well, hold on. I keep tiring of
We're kind of bored. Where are you from?
They're not going to delay the program. What?
I got you, Sarah.
Science, this is first and foremost science. There are two genders. This is about common sense. This is about fairness and safety as well. Ensuring that women are protected when they play sports, whether it's on the court or in the locker room. Frankly, it's disturbing when we come to this point in our country. This is even an issue to be debated for the Supreme Court. But sadly, it is. It's very important we prevail here on behalf of
When I count to 3, I want y'all to give me the biggest cheer ever, okay? Ready? 1, 2, 3. All right, let's do it one more time, okay? 1.
Yeah, please. Until you comply. So in order for there to be common ground, I believe that I do believe that there
I got one, but there was someone that was counting for this class. Thank you.
I know you're amazing. What contact?
Going to
I'm gonna be at 6 and I on Friday for.
Oh, amazing!
Yeah,
Oh,
I'm
nice.
looking forward to it.
There. Is choir gonna come? The choir's gonna come. Nice. Yeah, I'm really. Have you been before? I've been before. I haven't been since. It's good. I know. Yeah. Yeah, I'm excited that you're right. It's like a really special. Hello. How's it going? Yeah. How's it going? Oh, good. Yes, all the layers. All the...
Yeah, of course. But it's so nice. You're dropping everything.
It's a lot harder to drop. Okay. Well, thank you. You want to go infiltrate with me? Go ahead.
Finally, a word about mootness. When trying to avoid mootness below, Hecox told the court, I intend to play women's club soccer this semester, next semester, and through the remainder of my time at BSU. A contradictory post-cert affidavit does not make it absolutely clear this controversy is over, so Hecox's formidable burden isn't met, and this case isn't moot. I welcome the court's questions.
There'll probably be some questions about mootness, but I'd like you to, in focusing on the equal protection analysis, the sex classifications in sports is not being challenged.
That's correct.
How does that work in this case when we're talking about one individual being accepted from a particular or included in a particular category?
There's no basis for heightened scrutiny, intermediate scrutiny in that situation, Your Honor. If the sex-based line passes intermediate scrutiny, which no one disputes that it does, then the edge cases, the potential exceptions, that's all rational basis review.
That makes no sense to me, all right? And I don't know how you can say sex classification is not being challenged. There's no question here that a male who identifies as a female, but it's a male, is being excluded from a female sport, correct?
That's correct.
All right? By its nature, that's a sex classification. And all sex classifications, we have said repeatedly in our case law, require intermediate scrutiny. Now, what you're saying is, well, she's not challenging a male's generally not playing. She just doesn't want to be the one male excluded. So it's a subclass of people that she's challenging, correct?
Yes, I think that is correct.
All right. So how do you square our various case law, Caban, Lear, Claiborne, VMI in particular, all of whom involved a subclass of people who challenged on equal protection grounds their exclusion from a definition?
I'm happy to take those cases in order, Your Honor, starting with Caban. There was no notion of as-applied anything in Caban. In Caban, it was a facial challenge to the statute, and individual circumstances were used as examples to prove that the statute was overbroad and lacked a substantial fit.
That's the point. That's what she's saying here, that the state interest here is the safety of women, correct? And promoting competition. That's the state interest. And in Caban, the state interest was in ensuring that only children with active parents, let's say, were given a state benefit, correct?
Yes, and Caban was struck down facially. The statute was considered unjustified.
How about Lear?
In Lear, we had the same.
That's the opposite. That's the subclass, the people who were excluded.
In Lear, the court said the law would be justified with respect to you, plaintiff, and because the law would be justified with respect to you, you are not able to challenge the law elsewhere.
All right.
So the
How
court
about
says,
VMI? That distinction doesn't make any sense to me. It's still an exception. It's a subclass of people who are covered by the law and others are not. That's what we said.
The VMI case is the flip side of Idaho's law. The VMI case, equal opportunity required letting women in to previously single-sex spaces. In this case, equal opportunity for women requires giving women separate spaces, and VMI said that was okay. VMI said separate housing.
That's begging the very question at issue here. You can have a sex classification based on sex. You just have to have a reason for it and one that matches your exclusion. What you're trying to say is we don't even look at the reason to see if it has a scientific basis.
The reason we don't look at the reason in this case to see whether there's a scientific basis is because no one disputes that there is a scientific basis for separate sports.
Oh, but there is a dispute of that.
I'm sorry. Are you then saying, Mr. Hurst, that there really is no such thing as an as-applied equal protection challenge?
No, Your Honor, but what I am saying is that equal protection, the question is whether the classification is valid and not whether it makes sense in individual situations.
But that sounds to me as though, and I think our precedent is actually very sparse in this area, sort of surprisingly sparse. But it sounds to me as what you're saying is, as long as the classification is facially valid, a person does not get to come in and say that with respect to some subclass, a small subclass in this case, a person doesn't get to say with respect to some subclass, there's a mismatch, that the justification has run out, that the justification doesn't apply. You're saying that that really is just not an available argument.
I agree that is not an available argument, and I think this court has taken that approach, our approach, in cases from Conn v. Shevin all the way to Wynn, and Wynn is the best example because there the petitioner had been raised in the United States by the U.S. citizen father, and the court said Congress's interest in making sure there's a connection with the United States is enough to justify the classification. Well, this petitioner obviously had the connection with the United States. There was no basis to apply these justifications to that petitioner. Didn't matter.
I mean, one thing that this case could be about is, and this case I mean generally, this litigation, is whether the plaintiffs are right here that there is a mismatch, right? You know, and some of your briefing addresses that question, right? You can take all the hormones in the world, you can take all the puberty blockers in the world, you say, and there still will be a competitive advantage. That's one thing that this litigation could be about and one way to resolve this litigation. Another thing that this litigation could be about is this deeper and, as I say, surprisingly unanswered in my mind, equal protection question about what an as-applied equal protection challenge is and whether they exist. And I guess, you know, you're suggesting that we should, well, I don't really know what you're suggesting, because here you're saying, look, just do it that way. They could be right on the science, and we would still win. A lot of your briefing really contests their view of the science. So which way should we think about this case?
We think that equal protection jurisprudence is about the validity of classifications. It takes a classification to trigger the doctrines to begin with, and then you ask, is the classification justified under intermediate scrutiny? And so that we think that's the right approach. Is the classification justified? Not is it justified in each individual instance, because as Wynn said, this court has never held, Wynn said, that a law has to be capable of achieving its ultimate objective in every instance. And as soon as that possibility of forcing the legislature to justify the law with respect to individual plaintiffs is on the table, intermediate scrutiny is over. That is strict scrutiny.
Can I question the premise that you are putting forward? Even if I agree with you that equal protection is about, is this classification justified? I think that begs the question, what is the classification? And so to the extent that you have an individual who says what is happening in this law is that it is treating someone who is transgender but who does not have, because of the medical interventions and the things that have been done, who does not have the same threat to physical competition and safety and all of the reasons that the state puts forward, that's actually a different class, says this individual. So you're not treating the class the same, and you're not, how do you respond to that? In other words, the as-applied challenge essentially redefines the class, or one could think of it as that. And so what's wrong with that, number one, and how do you square that with our holdings in Caban, which Lair later described in this way? In other words, Lair suggested that Caban was establishing that as-applied challenges of this nature do exist.
Certainly, take the second question first.
Yes.
Caban says nothing about as-applied. I know that Lair says later this was an as-applied case, but simply reading Caban, it does not say that. It simply applies intermediate.
No, I understand, but those two cases were in juxtaposition with one another, yes. And Lair comes out the way it does, distinguishing Caban on the basis that it's an as-applied challenge, and we in Lair have a facial challenge, and it's basically the same facts. So if you're right those two cases can't come out the way they do.
I don't think so, Your Honor. Again, the layer was actually briefed as a standing argument of maybe you might be able to argue that this law is overbroad, but you individually are not in the overbroad part, and therefore you don't get to challenge it. The court didn't use standing language, like express standing language in the opinion, but that is the logic of the opinion.
Mr. Hurst?
Yes.
There's another way to think about the case. Your friends on the other side posit, and that is that transgender status should be conceived of as a discrete and insular class subject to scrutiny, heightened scrutiny in and of itself, given the history of de jure discrimination against transgender individuals in this country over history, in immigration and family law, cross-dressing statutes. They give a long laundry list, and I'd like you to respond to that.
Certainly, on the de jure discrimination point specifically, there has been some discrimination against transgender people, significant discrimination against transgender people in the history of this country. The same can be said of many groups. The same could have been said of the mentally disabled in Cleburne, et cetera, et cetera. I think Justice Alito's concurrence in Scrimeti is helpful with this in saying this quasi-suspect class or suspect class process, what we're really looking for is classes that look like race or like sex. And if you compare the discrimination in this case, where not one of the laws they cite actually classifies expressly on the basis of transgender status, if we look at that history and we compare it to the history of African Americans and women who were not able to vote, who were not able to own property, who had express classifications based on their status written into the law for most of this country's history, these things don't compare. They're just not alike.
I'm sorry.
No, please.
Okay.
There are two things in that answer that are kind of at odds with one another. You start by saying you don't question that there's a history of discrimination, assumed de jure, in this country. And then you say, well, but they don't classify on that basis. How should we think about that?
I think that the famous footnote 4 helps, right? Has it been a discrete and insular minority? Has it been a group of people that were recognized as a group where laws were passed on the basis of their membership in that group, demonstrating that they lacked the political power to protect themselves in the political process? This is from Justice Barrett's concurrence, of course. We just don't have any of that here. All they can point to is conduct. It says, no cross-dressing, no drag performances in bars, these kinds of things. As I think our friends on the other side would admit, people cross-dress who aren't transgender. This is not a classification on that basis.
What do you do with the legislative history in this case, where the people who introduced the bill called it a transgender bar? So you in answering Justice Gorsuch, you said there's no evidence of that, but there's certainly a lot of comments in this bill when it was passed.
Your Honor, I respectfully disagree. I am aware of nothing in the legislative record that says that. I know that the Ninth Circuit opinion says that, but if you'll notice, the key quote that the Ninth Circuit relies on puts the words transgender women in brackets. And if you look up that colloquy in the legislative record, in their transcript that they provided in the district court, the word transgender, gender identity, et cetera, do not appear in that section of the transcript.
Can I go back to the mootness question that Justice Thomas talked about, but we've not addressed here at all? Yes, this respondent made certain allegations about her intent at a certain point, but she signed an affidavit with this court attesting that she has permanently stopped playing sports covered by the ban. She will not try for any school-sponsored women's sports, and in fact, I think she'll finish school very shortly. And there's no reason to question the sincerity of that belief, given that dropping out of sports puts you at a disadvantage where you lose your competitive edge, and she's going to graduate soon. How is this different than Atchison Hotel, where the person in the litigation made representations that she intended to visit and continue visiting hotels in the future, and then, when the case got before us, she voluntarily dismissed those suits, like here, with prejudice, and we then directed that the case be considered moot? How is that different?
To begin with,
I add one further difference between the two cases. Here, it's not like she's attempting to avoid us reaching the question. In just a little while, we're going to reach the identical question in another case. So we don't have a subterfuge in attempting to stop the court from reaching an important legal question.
I'll start with Atchison Hotels, Your Honor. In Atchison Hotels, no one disputed that plaintiff's plans going forward. In this case, even the district court does not credit the plaintiff's plans going forward. The district court struck the notice of dismissal and said, Hecox's plans have changed before, Hecox's plans could change again, and also the court feels that this is somewhat manipulative in order to escape the Supreme Court's jurisdiction. None of that existed in Atchison Hotels, and that puts us in City of Erie territory, where in that case, the premises were sold, the business was closed, the owner was in his 70s, and they said, that's not enough. You could still reopen this business. Your company is still incorporated. Under these circumstances, where it's the respondent seeking through post-certiorari maneuvers to moot the case, that isn't enough. This case isn't moot.
Thank you, counsel. Justice Thomas.
Does the justification for a classification, as you have in Title IX, male-female sports, let's take, for example, an individual male who is not a good athlete, say a lousy tennis player, and does not make the women's and wants to try out for the women's tennis team, and he said, there is no way I'm better than the women's tennis players. How is that different from what you're being required to do here?
It's not all different, Your Honor, and that's exactly what we're concerned about, that their arguments about needing to make exceptions from an otherwise valid classification for people for whom that classification doesn't make sense, those arguments don't limit themselves to people who identify as transgender. Many males could say, I can't really compete with the women's basketball team, and therefore I should be able to try out. And I haven't seen an answer from the other side as to why they couldn't, beyond, I correct myself. They say that, well, those people don't face the same dignitary harm as transgender people. But I don't see how that's relevant to the intermediate scrutiny analysis. The analysis is this classification substantially related to a legitimate state interest? The person's reasons for wanting to violate the classification don't come into the analysis.
Justice Alito.
Justice Sotomayor raised the question whether the issues here are identical to the issues in the case we're going to hear in a couple of minutes, and I'd appreciate your views on that. Suppose we affirm or reverse in this case, in the other case, would that leave something undecided with respect to your case?
Yes, Your Honor. Our case involves the issue of the constitutional definition of sex, which the Ninth Circuit made a decision about, what sex means for constitutional purposes. The Fourth Circuit did not make that decision. We will be bound by that decision going forward unless the court reaches that question. That said, I would dispute the premise of the question, because whether or not the court has Article III jurisdiction in this case does not depend on what the court might do another day in a different case.
No, that wasn't the premise of the question. It was just an attempt to explore the consequences of deciding the mootness issue one way or the other. Thank you.
Thank you, Your Honor.
Justice Sotomayor.
There's a Munsingware GVR that's being agreed to here. So you're not bound by anything in this case. And our decision there will inform any new decision in the Ninth Circuit on this issue, correct? Whatever analysis we adopt in the Little case will control what happens in a new case.
That is the law, Your Honor, yes.
All right. With respect to the Erie case, there, the 90-year-old man never said he didn't intend to open another business. He just said this business. And that was the distinction we saw. Here, she has said, I don't intend to do this. Now, every other promise that she made in this litigation, that she was going to continue trying out, that she was going to stay in sports, held true until this case and the negative attention she received, correct? To say she misrepresented her intent is going a little extreme when she honored all her previous intents and only changed your mind when new circumstances arose, i.e., the notoriety of this case, correct?
No, Your Honor, nothing changed externally to the plaintiff. The plaintiff's affidavit filed in this court says that there has been negative attention and so forth since the beginning of this case. The only thing that changed is this court granted certiorari, and then after that, the plaintiff said, I want out, and so I will stop playing sports.
Do you dispute that having a case named after you makes your infamy live forever?
No,
you don't think that Brown and any of the other named plaintiffs that we have in famous cases drawn attention to those people as people? Have you studied your law cases? Students do all the time. I think one of my colleagues had a course where they looked at the lives of the plaintiffs. Do you doubt that having a named case with such an eventful event is going to continue attention on this person?
I don't doubt there will be attention, and I confess—
Negative attention.
I confess I have studied a few law cases, but—
have you studied the people?
To some degree, Your Honor. What I would disagree with is there's no background principle of plaintiffs get to leave the litigation whenever they want. Even Rule 41, even in just the district court, the rule is that once the litigation hits a certain point, you can't leave.
So what you're going to assume, I know you don't want to, that you were to lose this case, you would say that we have to force an unwilling plaintiff who has offered to dismiss with prejudice, promised not to incur this activity again, we would force that person to continue prosecuting this case.
The court did in City of Erie.
That it did there, but is it the right thing to do? We didn't do it in Atchison.
In Atchison, no one disputed that the case was moot. The only question was which Article 3 question would be decided first. In this case, we dispute the case is moot. We dispute all of the facts that this is based on. This is a formidable burden that Hecox bears. That's from Nike, already be Nike, to show that it is absolutely clear that this conduct cannot be reasonably expected to reoccur. We think, as the district court said in its striking order, that based on the changing history here, based on the past conduct, as Scalia mentioned in his footnote 3 of his City of Erie concurrence, there is a reasonable basis to doubt whether Hecox's current plans are the final plans. And as long as there's a reasonable basis not to credit the current plans, Article 3 lets the court hear the case.
Justice Kagan?
Mr. Harris, I want to take you back to our conversation about whether there's such a thing as applied equal protection challenges, and ask you for two things. The first is I do think that runs counter to a couple of things that we think of as basic principles of constitutional law, and maybe equal protection law particularly. In constitutional law, we often say as-applied challenges are the preferred mode of constitutional adjudication. Certainly, we have not erected bars to them in any other area, as far as I understand it. And then in equal protection law, we say all the time things like people need to be treated as individuals and not just as members of a group. And I'm wondering whether both of those principles don't suggest that any bar on equal protection, as applied equal protection challenges, is just wrong, is off. And then the second thing I want you to do after you do that is assume for me that there is such a thing, and to tell me how, in your view, an as-applied equal protection challenge ought to work in this case.
Certainly, Your Honor. The first answer would be, I recognize those principles that Your Honor is alluding to. The contrary principle would be the very nature of intermediate scrutiny analysis, that it is always possible, if you only have a substantial fit supporting legislation, then it is always possible to find people whom it doesn't fit, and then we're in strict scrutiny.
So I completely take that point, Mr. Hurst. I mean, you're exactly right, and of course, intermediate scrutiny is different from strict scrutiny. It doesn't require the, almost perfection that strict scrutiny does. Completely take the point, but isn't that point really addressed to what we often consider in these areas, which is to facial challenges, right? So when you bring a facial challenge, of course, that's right, that you're allowed to have over-inclusiveness and under-inclusiveness and a lack of a perfect fit, but that the nature of an as-applied challenge is different.
Certainly the court could do that, Your Honor. The court has not done that before, as I think we both agree. And the result of that would be judge-made exceptions to laws anytime judges thought they didn't make sense for particular classes of plaintiffs. And the deference to the legislature that should exist, to some degree, even under intermediate scrutiny, would be done away with. It would be gone. And then the administrability justification for many sex-based classifications, including this one, would also be gone, because you could no longer administer the classification evenly. You would have to make as many exceptions as courts thought you needed to make. So it's really an institutional competence thing or institutional power thing between courts and legislature.
So you're suggesting to me that the whole thing is just unworkable and we shouldn't, but flip to the second prong of my question, which is, suppose we said, as applied equal protection challenges exist as applied anything challenges do. What would it look like, do you think? What should it look like?
Yeah, I'm not sure what it should look like. I can say what it does look like in this case and why we think there's a problem with it.
So you're not willing to take me on my second path, which is like, let's assume that there is such a thing as this challenge.
Yes. I mean, the most I can say, I doubt this is a satisfactory answer, Your Honor, but the most I can say is that the as-applied nature of a challenge might go to the remedy. The legal analysis still focuses on the classification and the justification for the classification. And once we're talking about individuals, we're not talking about a classification anymore.
Yeah, I mean, that doesn't seem like much of an as-applied challenge, right? You have to prove the exact same thing as you do in a facial challenge, but don't worry because you only get relief as to you. So that's not a true as-applied challenge.
And I'm having trouble coming up with what it could look like, because it will always be possible to carve the class down further, right? I mean, so if they say that their class, that their subclass, I guess, subclass of males, is males who identify as transgender, then we would come back and say, well, only something like 10% of males who identify as transgender take the testosterone suppression. And then they might say, well, okay, no, the class is just the males who take the testosterone suppression. And then we might come back and say, well, according to the record, according to their own expert, of males who take testosterone suppression, only 1/4 of them are able to achieve the appropriate, able to achieve ordinary levels of testosterone for women. And the other 3/4 would still have an advantage, and therefore we'd be justified 75%, pretty good fit in intermediate scrutiny, and we'd be justified with the law. But then they can just change the class again. They can say, aha, no, our class is males who identify as transgender, who suppress their testosterone, and who suppress their testosterone successfully, and are able to get it down to where they don't have a competitive advantage. And at that point, we can say, if you can define the class so precisely, you're going to force the state to define the class that precisely. It's going to be enormously burdensome for everyone, and the state can never win, because whenever the state points to the fit in the statute, they just redefine their class as only the people who are outside the fit.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
To follow up on something you were talking about, Justice Sotomayor, would your constitutional position be different if the law explicitly stated that transgender women and girls cannot participate in women's and girls' sports?
My answer to that depends on what's in the rest of the law. So I would refer back to Scrimetti and say, it's not a magic words test. The mere presence of the word transgender in the statute is not enough to make it a transgender-based classification.
What would make it?
If the law, either expressly or through its effect, let all males except males who identify as transgender participate in female sports, but made it so that somebody's ability to play in female sports depended on transgender identity.
Assume that the law does not allow males to play in women's and girls' sports, and then explicitly says, a separate provision, transgender women and girls, biological males who identify as female, cannot play in women's and girls' sports. Would your constitutional position be any different in that situation?
No, Your Honor, I think that's Scrimetti. I think that would be a reference to transgender identity, but the law's application would never turn on transgender identity, so it wouldn't be a transgender status.
Even if it says transgender?
The word transgender in the statute might be relevant to a pretext analysis, but it wouldn't be relevant to facial classification if that word did not change how that statute applied in practice.
How many states allow biological males who identify as females, transgender women and girls, to play in women's and girls' sports?
Statutorily, I'm aware of 27 states that take our side and do not permit that, and 23 states that take the other side and do permit it.
And those states who do allow it, is your position that they are violating the Constitution, the Equal Protection Clause, rights of biological girls and women by allowing that? Or do you say that's up to each state to decide, and that the Constitution gives discretion to the state whether to allow it or not to allow it?
I have not yet been persuaded by a constitutional theory that would let us use the Equal Protection Clause to impose our policy on other states in this matter.
Okay.
Justice Barrett.
I have some questions about the implications of your theory. So how would your theory play out if we're talking about 6-year-olds, where there's no difference between boys and girls in terms of athletic ability, testosterone levels, et cetera? Could you have sex-separated teams then? Or sorry, sex-separated teams by biological sex and not allow trans girls on the...
Certainly, Your Honor. First, I'd like to explain how the statute applies to that situation so I can put my answer in context. There are no 6-year-olds in the state to whom the statute applies because there are no school-sponsored...
That's why it was a hypothetical.
Okay, right. Yes, like it would be the normal intermediate scrutiny analysis. And are we saying it applies only to 6-year-olds or to everybody across the board?
Well, I'm just trying to give you a hypo... I mean, yours is driven by testosterone levels and differences in athletic capability. So I'm asking you, what if you try to take that out of the equation and you're just drawing the line based on biological sex and saying that trans girls can't be on the girls' team in an age group that's prepubescent?
The record in this case does not support the notion that males lack an athletic advantage at 6 years old. That's about as early as the science goes from what's in the record. And even at that age, males have about a 5% athletic advantage over girls in most situations. Now, if this is not a level of competition where anybody cares about that, the simple solution is the solution you see in most places, which is you have co-ed sports, you don't divide the teams based on sex, and everybody can play. And Idaho's law does nothing to interfere with that.
And remind me whether Idaho's law, and I guess your answer made me think of this, and I guess this goes to the question of whether the law discriminates on the basis of trans status. Is it true that biological girls, trans boys, can play on boys' teams?
Anyone can play on boys' teams, Your Honor.
Anyone can play on boys' teams, okay. And to this point about medical uncertainty and scientific uncertainty, you were talking about what advantages you might have even that are apart from testosterone levels. Mm-hmm. Your friends on the other side say that, listen, that science is uncertain, and so we need more factual development. It's not really clear how much of an athletic advantage boys and men have if their testosterone levels are below a certain point. How does that play out? Tell me why we don't need more fact-finding, or what is the state's burden in showing what the state of scientific certainty is? Do we have to defer to the state? Presumably at some point, if deference is due, the state would have too little scientific evidence to really get that deference. Tell me how to think about that.
The first question would be, are we applying intermediate scrutiny? And we argue that the court shouldn't. But leaving that aside, if the court is applying intermediate scrutiny, then we'd say it's Turner Broadcasting that says the legislature, First Amendment case, applied intermediate scrutiny and said under intermediate scrutiny, the legislature has to draw reasonable inferences from substantial evidence. It does not need to act only on scientific consensus, which is what the district court in this case assumed incorrectly.
Thank you.
Justice Jackson?
So I guess I'm going back to your discussion with Justice Kagan. I'm not sure I understand why you're characterizing the as-applied challenge in practice as the individual coming back and proposing a different classification, as though we're doing an analysis of the classification in the way that you suggest. I thought that the state has a classification that is its general rule. No individuals who identify as female but were sex at birth male can play in women's sports, and that the individual then is merely seeking an exception based on their individual capacity, because the state's general rule is based on fairness and medical science and all of these things. Do I have this, like, they're not proposing an alternative class necessarily, they are just saying that I should be accepted from that general rule on this basis.
We agree that an exception is what they are seeking, Your Honor. And it's an exception based on transgender status, again.
But that's the way the rule used to work, right? I just want to be clear about what we're talking about here.
Sure.
I understood that this law originally was exactly that. That you basically said no transgender women in girls' sports, but we'll look at your evidence and look at your circumstances and decide whether or not you individually can be included.
So
is that what used to happen?
As a matter of Idaho law, there was no law whatsoever before this.
Is that what was happening on the ground in Idaho law?
That's what NCAA policy permitted from 2010 to 2022. Before 2010, the NCAA policy matched ours. Since 2025, the NCAA policy has matched ours.
Okay.
But
what I'm asking is, if that's the ask here, not that all transgender women be allowed, but that this particular plaintiff be allowed based on their circumstances, why is that so not administrable or proposing a different classification that we're not going to be able to sustain? I don't understand that.
So first as to administrability, Your Honor, making sure that a transgender athlete does not have an unfair advantage would require ongoing testosterone monitoring because circulating testosterone can fluctuate. That is invasive. That is intrusive.
No, but that's the burden of the person. The person who wants to play, he has to demonstrate to you, to whatever degree of scientific certainty, that they don't have a competitive advantage. Why would you not allow that? I guess I don't understand.
The second answer is that there's nothing in that argument that limits itself to transgender identifying athletes. If this athlete doesn't have an advantage over women and therefore can compete safely, then there are other athletes that could say for different reasons that they don't have an unfair advantage and therefore they could compete safely.
Yes, and I understand that, and there are legal arguments. Let me ask you something about the classification. I guess I'm struggling to understand how you can say that this law doesn't classify on the basis of transgender status. The law expressly aims to ensure that transgender women can't play on women's sports teams. So why is that not a classification on the basis of transgender status?
I'd apply Scrimetti again. The question is whether the application of the law turns on transgender status, and it doesn't. It turns on sex. The legislature did not want to exclude transgender people from sports. It wanted to keep women's sports women only and exclude males from women's sports.
No, I understand, but with respect to two individuals, a cis woman and a trans woman, who both want to play on a team that reflects their gender identity, this law operates differently based on their sex, right?
The law does operate differently based on their sex, as Your Honor just said. It does not operate differently based on their transgender identity.
But it treats transgender women different than cis women, doesn't it?
It has a disparate impact because men who identify as transgender have a different reason for wanting to play women's sports than women, than biological females do, right? But if that were enough, then Scrimetti would have come out a different way, Gadulli would have come out a different way, other cases would have gone a different way. I'm blanking on the other ones.
All right, finally, let me just ask you about mootness, because it's a little odd, I think, that a defendant would not want a case dismissed. Ordinarily, the defendant is the one who's claiming mootness because they've been sued. So this plaintiff has brought a claim against you, and the claim relates to your policy about college sports. And as I understand, the plaintiff is about to graduate. So wouldn't we have a mootness problem potentially notwithstanding any representations that the plaintiff made?
I don't think so, Your Honor. I'd look to Camreta as the case that tells us the best case for telling us how we analyze mootness in this situation. It's, does the petitioner still have an interest in continuing the litigation?
Only for a few more months. What if this decision doesn't come out until June and she graduates in May?
It's my understanding at this point, I defer to my friends here, it's my understanding at this point that May graduation is not possible.
For this individual?
For this individual, that's correct.
All right, thank you.
Thank you.
Thank you, counsel. Mr. Mupan?
Mr. Chief Justice, and may it please the court. It is undisputed that states may separate their sports teams based on sex in light of the real biological differences between males and females. States may equally apply that valid sex-based rule to biological males who self-identify as female. Denying a special accommodation to trans-identifying individuals does not discriminate on the basis of sex or gender identity or deny equal protection. All of that remains true, even assuming a man could take drugs that eliminate his sex-based physiological advantages. The law is reasonably tailored, regardless of whether it is perfectly tailored as applied to any such tiny subset of men. And states are not required to redefine sex or monitor the testosterone levels of female athletes. In short, male athletes who take performance-altering drugs are not similarly situated to female athletes, and states need not treat them the same. I welcome this court's questions.
Would you elaborate on what you alluded to, and that is that whether or not a state has to, its asserted interest in classifications has to bear out in each individual case? That seems to be what the applied challenges in individual cases would require.
That's right. So intermediate scrutiny requires a substantial relation or a reasonable fit, which is not a perfect fit. And this court has recognized, and I'd point this court to Edge Broadcasting in particular, it focused on this exact issue of if the law is substantially related in general, can an individual come in and say, well, as applied to me individually, it's not. And the court said, no, we're not going to allow you to do that because that would essentially convert intermediate scrutiny into strict scrutiny on an as-applied basis. Now, I'm not disputing that you can sometimes bring as-applied claims under intermediate scrutiny. So if, for example, you had a law that applied, this sort of law that applied to sports, but also math and also chess, it might be that as applied to math or chess, it was invalid, but it was valid as to sports because for math and chess, at the level of the classification, it's not reasonably tailored. But here, critically, everyone agrees that for sports, for 99% of men, it's reasonably tailored. It's just the 1% of trans-identifying individuals who take drugs and then those drugs are effective that's a problem. And this court's decision in Michael M. makes clear that that's not a viable as-applied claim. In Michael M., this court upheld a statutory rape law that applied differently to men than women, and the rationale was because women faced a unique risk of pregnancy. But of course, if either the male rapist or the female victim was infertile, there'd be no pregnancy. So on their theory, you could have come in and said, well, I have an as-applied claim that I was infertile, so it was okay to rape the underage girl. And this court not only rejected that, the court said it would be ludicrous to say that you could bring an as-applied claim for prepubescent girls. That's just not the way as-applied scrutiny works in intermediate scrutiny cases. That's equally true, as my friend said, in Wynn. In the court's decision in Wynn, the justification for the law was making sure that the parent knew that they were the parent and had an opportunity to have a relationship with the parent. But Wynn's father knew about the birth, was present with Wynn the whole time, and brought Wynn to the United States. Nevertheless, the court held for the class of men overall, it was reasonably tailored, and they weren't going to focus on the specific facts of Wynn.
You started, Mr. Mupan, by saying that you did think that there were as-applied equal protection challenges, and giving an example of, well, if it had also applied to the chess team or something. But that doesn't seem like an as-applied challenge to me. That seems as though there's just a provision of the law that's facially invalid, right? So let's put those kinds of cases aside where you can split the law up and say this part is facially invalid, this part isn't, and focus instead on like real as-applied challenges. Your classification is basically okay, let's posit, because there's a substantial relationship to your goal. Is there ever a time where a person can come in either on behalf of herself or on behalf of a subclass and say, notwithstanding that there is no a valid facial challenge here, there is an as-applied challenge, this subclass has to be exempted?
So I don't think this court's cases have ever squarely addressed that. I think if it could be brought, it would have to be a very substantial percentage. So to give you a stylized hypothetical, if you had a law that regulated on the basis of sex, and you could imagine 3 subgroups of males, for subgroup 1 and subgroup 2, each of whom were a third of men, it was reasonably tailored. But for subgroup 3, which was a third of men, it wasn't. Maybe in a circumstance like that, the third subgroup could come in and say, for a third of the applications of this law, it's not reasonably tailored. That's not enough of a substantial fit, at least for us, even if you're going to uphold the law for the other 2/3 of
But why does it have to be that many people? Why? Why? I don't understand why that subclass can't make this showing and get the remedy as to them.
Because if it's one person, you're basically converting the law into strict scrutiny.
But you're not. You're not. I mean, because what you're doing is you're allowing that individual to get the remedy that we've said in cases like CASA is the only thing that's available, that you can't have this flow to everybody. It's just about this individual and whether or not he's been unconstitutionally treated.
So again, because if the law is reasonably tailored for 99.99999% of people, and you come up with a point fraction of percent and say that that person has a viable claim, that's more than you would ever require under strict scrutiny. I don't know of any.
No, but I mean, well, what's the result of that? If you're making a facial challenge, I understand that you're saying that if the law has such a broad sweep of constitutionality, then we're not going to strike this thing down just because we can identify one person for whom it doesn't apply. But if you are that one person and you can show that this is unconstitutional as applied to you, I guess I don't understand why it matters that it's constitutional as applied to 99.9% of the other people.
Well, because I think you're begging the question when you say it's unconstitutional applied to you. Laws that classify on the basis of sex only need to be reasonably related. And so if it's reasonably related because it's tailored for 99% of people, then it is constitutional even applied to you.
Even as applied to you. So you are saying there is no such thing as an as applied intermediate scrutiny challenge.
Again, if there was one where it was a third of the people, I can maybe understand a claim that the third of people, it's not reasonably related for them, even though it is for 2/3 of the people. I'm just saying that when the numbers get as small as they are here, that claim's not viable, and we know that from this court's cases. Again, Michael M., every infertile man.
No, I understand, but we didn't do that same kind of quantitative analysis in Caban, right? We didn't ask the husband in Caban to figure out where he stood relative to all husbands who were to whom this was applied.
Right. So let me talk about both Caban and Lair. So Caban is not an as-applied challenge. Caban did not say that there was some set of people for whom that law was valid. The differential treatment
itself. Lair said that about Caban.
So what Lair held was the father in Lair had abandoned the child. And what Lair essentially said is, if the mother had abandoned the child, the mother wouldn't get a veto.
Can I read to you what Lair said about Caban? Discussing Caban, Lair explained, quote, "We have held that these statutes may not constitutionally be applied in that class of cases where the mother and father are in fact similarly situated with regard to their relationship to the child." So Lair is interpreting Caban as an as-applied challenge, isolating a subset of people where there's not actual similarly situated circumstances, and Lair is different. It is a facial challenge. It is in opposition. No?
What that sentence in Lair, the facts of Lair, there was no differential treatment. The father in Lair had abandoned the child, and the court basically rejected his claim, because if a mother had abandoned the child, the mother also wouldn't get a veto. So Lair's a case where the plaintiff lost because there was no differential treatment at all. Caban is a case where the plaintiff won because the classification couldn't be justified. The only way those cases would support their position is if either Caban or Lair had said there is some set of cases where the woman gets a veto but the father doesn't, and that's fine. And neither Caban nor Lair said that. This court has never said in those line of cases that the mother could get a veto but the father doesn't, and that's perfectly okay. So that's what they're arguing, and neither of those cases support it. You would also ask about VMI, so if I could just briefly address why VMI doesn't support them either. In VMI, the point was, yes, lots of women wouldn't want to go to VMI, but also lots of men wouldn't want to go to VMI. As to the set of people who were actually burdened by the exclusion, all of the women, the law was not fairly tailored. The argument that Virginia was making VMI was essentially equivalent to the following. If MIT said, most women and frankly most men can't meet our math and science standards, so we're just not going to allow women to come to MIT at all. Of course this court would reject that argument. That was the argument that they were making in VMI, that just very few women wanted to attend. But for the set of women who wanted to attend, the law was not properly tailored because there was no justification for excluding them.
Thank you, counsel. Justice Thomas? Justice Alito?
Under Title IX, what does the term sex mean?
We think it's properly interpreted pursuant to its ordinary traditional definition of biological sex, and I think probably given the time it was enacted, reproductive biology is probably the best way of understanding that.
Thank you.
Justice Sotomayor?
The problem I'm having with what you're doing now is you're doing exactly what Justice Stevens said should be done, and he admitted later in O'Connor that the court roundly rejected that in Caban and Lear. He wanted to do exactly what you said. He said, in dissent, this court should be in analyzing equal protection, contending that if the classification is justified in those cases in which the rule has its most frequent applications, then it doesn't violate equal protection. And then he said the court should presume that the law is entirely valid and require the challenger to demonstrate that its unjust applications are sufficiently numerous and serious to render it invalid. It's exactly what you said we should be doing. So you want us to accept what the dissent did and not what the majority said it was doing in Caban or Major. In BMI, Justice Scalia said the same thing, that taking the majority's logic to its logical conclusion, a single woman who wanted to attend could satisfy the admissions requirement would be enough for an as-applied challenge, and that shouldn't be the law. You're asking the court to adopt views expressed by two minority dissenting judges in this case. We've been doing an awful lot of that lately, but you're smiling because it's true, but you're asking us to adopt an approach that we have rejected as a majority court and accept what dissenters are doing, correct?
With all respect, no. Again, in Caban, nowhere in the majority opinion in Caban did they say this law is reasonable for certain classes of men, but it's not reasonable.
It did exactly. It said it's reasonable for fathers who don't support their children. It won't be reasonable for fathers who don't.
With all respect, Your Honor, it did not. Caban did not uphold that law as applied to any man who hadn't abandoned their child. Now, it is true Lairs upheld the law for someone who had abandoned their child, but the reason it upheld the law is because women who abandoned their child.
But the logic of the opinion is that if the reverse had been true, it would have ruled the way it did.
I don't think that's true, but even if you thought that was, sure.
No, I just have one last question. What's percentage enough? There are 2.8 million transgender people in the United States. That's an awfully big figure. I do understand that in Idaho, this was the first transgender child, but that just happenstance as to location. What makes a subclass meaningful to you? Is it 1%, 5%, 30%, 15%? One is not enough for you, but why?
Well, so I'll say...
When the numbers don't talk about the human beings.
So I'll say a couple of things about that, Your Honor. The first I'll say is if the distinction between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit, 1% surely has to be on the side that's reasonable. But if you don't want to just take the 1% on its own face, I would point your court, you want to focus on majority opinions or opinions for the court. Michael M. rejected a challenge, even though that law wouldn't For infertile either infertile rapists or infertile victims, the justification didn't apply. There are certainly more infertile people.
They did it on a different basis, which had to do with different harms.
No, that's not true, Your Honor. With
I
all
can read the
respect,
decision and tell you.
With all respect, that paragraph, it says, even setting aside the physical differences, it is ludicrous to think we have to exclude infertile children from this rape law. And there are certainly more infertile people than there are trans-identifying individuals who take these drugs and eliminate all their physical advantages. So if we just focus on holdings of this court, we know that this percentage is too small.
Justice Kagan?
Mr. Mubin, just assume with me that there is such a thing as a as-applied equal protection challenge. What would it take to bring that challenge? What should the plaintiff have to show?
I think they would have to show that, A, they are a substantial enough percentage to be able to bring an as-applied claim, and then as to that group, the law wasn't reasonably tailored for them.
And that they would have the burden on that. It's not for the state to come back and say, the state does not have to satisfy that burden initially.
I'm certainly not the first of the two reasons I said. I think if you thought that you could have a valid as-applied claim and they had made it through the gate of saying they were a big enough class, then I think consistent with normal intermediate scrutiny, I think the state does bear the burden of showing justification for that class. So I think the state would have it on the second step, the plaintiff would have it on the first step.
I see, so they have to sort of get through the gate of we're big enough for you to take us seriously, but then the state has it.
I think that would be how you would analyze it.
And I think you were asked this, but big enough to be taken seriously? Like, how do we decide that?
You know, again, the court's cases haven't really talked about it. I think the way I would think about it analytically is the difference between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit. So is there enough of a group here that we think that we're not essentially holding the state to perfection? If it's so close to perfection, then you're really undermining the difference between the two. If it's a big enough group that we're not asking for perfection.
I mean, are you really undermining the difference between the two? Because usually we think of the difference between the two with respect to facial challenges. So you have to do a whole lot less to show that the facial classification that you're making is okay.
I don't think so. I do think that you would very much be undermining the difference between the two if you said that even a single person could bring an as-applied intermediate scrutiny case. And again, I would urge Your Honor to read Edge Broadcasting. There's a whole section of the opinion that's on this exact issue and says exactly what I'm saying. Now, admittedly, it's a First Amendment case, but it's an intermediate scrutiny First Amendment case.
Thank you.
Justice Gorsuch?
If the class is big enough, in your discussions, say a third, as you discussed, might it just fail intermediate scrutiny facially? I mean, at some point, do they collapse?
So I agree that that's part of why these are so unusual. If there's a big enough group that you've excluded, you're exactly right. It might not be reasonably related as a whole, and so then it facially fails. But I could at least conceptualize a situation where it covers enough people validly that a facial challenge fails, but it covers a big enough group that it can't be justified for, then maybe you could bring an as-applied claim. I don't think this court really needs to grapple with these fairly tricky analytical questions because this is the world's easiest as-applied claim to reject. It is a fraction of a percent. Whatever as-applied claim you could bring, it cannot possibly be a fraction of the percent. That would be totally inconsistent with this court's decision in Michael M. and Wynn, both of which rejected claims by people who had a much greater percentage than a fraction of a percent.
As you know, a lot of states allow biological males who identify as female, transgender women and girls to play in women's and girls' sports. And you heard Idaho say that those states, other states, constitutionally may allow that consistent with the Equal Protection Clause. Do you agree with that?
So we've been challenging those laws under Title IX in lower courts, and as we said in our brief, we would urge the court to just reserve judgment.
Can you answer the Equal Protection Clause question that I just asked?
I'm not sure if we've taken a position on the equal protection piece.
Do you have a position?
I don't right now.
Okay, and on Title IX, footnote 2 of your brief seemed to say that you don't have a position on how Title IX applies to those states as well.
No, so we are actively litigating in lower courts, and we are saying that they are violating Title IX. What the footnote said is it's a very different question. We would urge this court to make clear it's not resolving that question one way or the other by what it says in this case.
Okay, so you have a position on it, but you don't want us to say anything about that issue.
It's a very different question analytically, and so...
I understand, that's why I'm asking.
Yes.
Yeah. Okay, thank you.
Justice Barrett.
So, Mr. Mupan, when Justice Kagan started asking the questions early on about the as-applied equal protection challenges, she pointed out that there was kind of a surprising dearth in the case law really grappling with this. But I think you wouldn't be getting all the questions that you're getting about Caban and Lair and Michael Lamb and VMI if it weren't the case that you can read some lines of cases either way. So let's say that there is this uncertainty. We haven't really confronted it. As far as I can tell, it's because it just wouldn't be relevant in strict scrutiny because it's often fatal in fact, or typically almost always fatal in fact. So it's really an intermediate scrutiny problem. Maybe it's a rational basis problem too. I mean, maybe this would have implications for all kinds of review. Because it seems to me that if you're never talking, in any case in which scrutiny is not talking about a perfect fit, you might have this problem. What would it do, essentially? I'm just trying to think about the ramifications of allowing as-applied challenges. It seems like it's at war with the theory of intermediate scrutiny for some of the reasons that Idaho said, because all lines, all classifications overshoot or undershoot, right? So can you imagine how intermediate scrutiny works? And this is, this isn't designed to be a layup or something. It's honestly just something I'm grappling with. How would it even work going forward?
So I'm not sure I can say a whole lot more than what I've already said, which is I do think it's a problem. The reason I think it's a problem is it's conflating the difference between strict scrutiny and a perfect fit, intermediate scrutiny and a reasonable fit. And I worry that if you allow as-applied claims to a small enough group, you're essentially collapsing the difference because you're essentially requiring a perfect fit. Because whenever you have a reasonable but not perfect fit, the subset who falls within that will come in and bring an as-applied claim. And so the state will essentially have to have perfectly tailored laws because any single person for whom you don't have a perfect fit could come in and bring an as-applied challenge.
Including, say, boys who just couldn't make the team because they weren't good enough, because the law, to the extent that it's designed to protect competitiveness and safety, et cetera, wouldn't pose the same danger in the case of a boy who just isn't good enough to make the male team, but perhaps could make the girl team.
At least arguably, depending on what their exact theory is for the justification.
Thanks.
Justice Jackson?
I guess I'm still struggling to understand why the state would have to have perfectly tailored laws. I would think the state would just have to make exceptions where people can demonstrate that the justification that makes the state's conduct constitutional doesn't apply to them.
So making exceptions is tailoring your law. That's literally what it means to tailor
No, but
law.
from the standpoint of a facial challenge, when we're asking whether this law has to be stricken completely because it isn't, perfectly tailored. What we're doing is a different exercise in the as-applied challenge. We're asking whether, even though this law is overbroad, we're assuming it's overbroad now because you've got in there some people to whom it should not be applied. What do we do about that? What is the remedy that those people can get? And what I hear you saying is they get no remedy unless they can demonstrate that there are enough people that this is sufficiently overbroad that it's no longer something the state can do.
Right.
And I don't understand why that is. Why wouldn't, when we identify people for whom this law operates unconstitutionally, that's the premise, because now I'm in remedy, right? The premise is that you have a person who's successfully made an as-applied challenge. This, to me, unconstitutional. You say, too bad, unless you can show that it's also unconstitutional with respect to a sizable number of other people. And I don't understand why that's the case.
Because I don't agree with the premise that the law operates unconstitutionally as to an individual person just because it doesn't, the justification for the law doesn't apply to that person. That's what this court held in both Wynn and Michael M. It recognized that the justification that was put forward for the law might not be true for each and every person the law applied to. But this court said, that's fine,
And if we read Caban and Lair to say something different, if I disagree with you, then we just...
Well, Wynn is the most recent of the cases. So
Okay.
even if you read the cases that way, and Wynn is explicit about this. Wynn explicitly says, I believe it's, I'm not going to get the page number right, but Wynn explicitly says that we recognize that there are some men who were present at the birth of their child, who have a DNA test to prove that they were the father, that have been with their kids their entire life. In fact, that was probably true of Wynn's father. Tough luck.
Okay, so Justice Barrett is worried, I think she said, about the implications of allowing as-applied challenges. I guess I'm worried about the implications of not. Because as Justice Kagan said, we have consistently said that facial challenges are really hard to get, that as-applied is really all there is. So now we're in a world in which you are setting up new barriers, in my view, to establishing an as-applied challenge. So at the end of the day, is your position that no matter how clear it is that the particular prescription is operating to disadvantage a particular group, that classifies you, treats you differently, you're just not going to be able to get a remedy for that individually anymore.
Let me take a step back, and then maybe this will help. Laws that classify, in general, are subject to rational basis review. Now, there's higher scrutiny for classifications on some things. For race, we have strict scrutiny. For sex, we only have intermediate scrutiny. What that means is it is okay to have a classification that doesn't operate perfectly for each and every person. So it's not the problem is that it's unconstitutional, but there's no remedy. The point is that it is constitutional,
I don't necessarily
even though
think
it's
that's the
overbroad.
takeaway. I think what that means is it's okay because we realize that in some circumstances, maybe even in many circumstances, this classification is justified. But when we can identify a situation in which it's not, I don't understand why a person can't bring that challenge.
Well, I can't say anything better than in both Michael and Wynn, the court recognized that there were people who it wasn't tailored for and they didn't give them a remedy.
Thank you.
Thank you, counsel. Ms. Hartnett?
Mr. Chief Justice, and may it please the court, Idaho concedes that HB 500 draws a sex-based line by categorically excluding all students with the biological sex of male from women's teams. Sex classifications like that are closely scrutinized under the Equal Protection Clause to ensure they rest on evidence, not supposition. Idaho's articulated justification for this line is to protect women's sports from birth-sex males because of their, quote, biological advantages. That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth-sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage. This court's cases have recognized that when the government's justification for a sex-based classification does not apply to a discrete subgroup of those classified, that classification is unconstitutional regarding that subgroup. And that holding in Caban, which I'm sure we'll discuss further, has been repeatedly referred to and reaffirmed, including more recently than Nguyen and Morales-Santana. Because the court can affirm based on sex discrimination, it's not necessary to reach the question of transgender status discrimination, but HB 500 also fails on that basis. If the court does not find the case moot, the preliminary injunction should be affirmed. I welcome the court's questions.
Couldn't you make a similar argument with respect to Title IX itself and the sex difference, the permission, the fact that you can have male and female sports?
No, Your Honor. So I think the point would be, the question would be, would the sex line that's drawn in sports, and that's a line that does exist, you know, as a commonplace line, is that substantially related to the important state interest?
Well, you could have individuals who, for example, don't present the problem physically outmatching women in a particular sport or a group of people who don't.
Right, and the broader goal here, of course, is not sex separation for its own sake. The idea is to have equality in sports, and that's the ultimate objective that I think we're all talking about, not separation for its own sake.
Well, my point is the argument that you're making now with respect to this subcategory, could it not also be made with respect to the sex separation in Title IX generally?
Occasionally there have been examples of a boy challenging the separate teams because they want access to a team that's not available for the boys because of the way Title IX works. To be clear, we have not aware of an example of a boy challenging the sex separation so that they can be on the girls' team where there's a boys' team that exists. In that case, the courts do look at that under intermediate scrutiny, and they determine that the overall goal of ensuring equality in sport opportunity for women and men allows for the distinction.
Counsel, I wonder if you could address what has been, I think, the basic focus of the discussion up till now, which is, as I see it anyway, whether or not we should view your position as a challenge to the distinction between boys and girls on the basis of sex, or whether or not you are perfectly comfortable with the distinction between boys and girls. You just want an exception to the biological definition of girls.
Thank you, Your Honor. We're not asking for a particular definition or even really an exception. I think what we're asking for, and it is similar to the nature of the challenge that was brought in Caban. The situation there where there are unmarried fathers that were barred completely from objecting to their child's adoption. And there the father said, we'd like to be able to have that objection. We have a substantial relationship with the children. And in the group, and there was actually a pretty tailored group in that case, in Justice Stevens' dissent, he points out, it has to be an older child, and there has to be a participation in the rearing. For that subgroup, they were allowed to challenge that and get the relief. And so, I do note too that Justice Stevens pointed out that it was an indeterminately small subgroup of an unknown number of fathers. So I think that's the analogy that we would draw here to what we're asking.
So what would be the appropriate inquiry? And it's asking you basically for your response to Mr. Mupan in particular, that going sort of challenge by challenge, whether it's based on a transgender status or anything else in the situation, is really transforming intermediate scrutiny to strict scrutiny.
We agree there would have to be a group. I don't think, in our view, in a way, at least the way that the cases have worked out, and this is Caban and Lair, it also goes through Nguyen and Morales-Santana. I would also direct the court to the illegitimacy or the non-marital children case. Those are Trimble and Lally. They're cited in the BPJ brief. In the same way, I think the court looks, is there a definable group that's not just a person who happens to not meet the fit, but actually a group where the rationale doesn't make sense for the subgroup. But the group can be somewhat specific. Like in the case of Caban, it was actually unmarried fathers who had acknowledged paternity and had a substantial relationship. In the Trimble case, it was non-marital children who had a confirmation of paternity and a relationship with the father.
Well, that sounds an awful lot like strict scrutiny, unless you're going to say whenever you can come forward with anything that is an exception to the boy-girl distinction. In any case at all, you can go forward with the strict scrutiny challenge, whether it's 1% or whether it's 12 people, and I'm just not quite sure, grasping why your position isn't really an effort to apply strict scrutiny to a distinction that we haven't applied it to.
Thank you, Your Honor. I mean, all I can say, and I do agree that cases are not that many in this context. I think it's possibly because facial challenges were more in vogue before, and now as-applied challenges are more preferred, and so that may be explaining why a statute in Caban, for example, wasn't viewed as carving out the statute for the people it couldn't be applied to versus facially invalidating it. But I do think it matters because it's not just a matter of fit that makes intermediate scrutiny different. There also has to be an important government interest, not a compelling one, and this is really critical. You can burden the right in intermediate scrutiny. So in Nguyen, for example, that person failed because he actually didn't take the steps that would be needed to confirm the paternity. So you're allowed to actually, he may have had a compelling case on a one-off basis that, hey, I actually do have that relationship with the citizen father when I was born abroad, but he didn't take the steps that he needed to do. The same thing with Lair, and the same thing with Lally and the Trimble-Lally line. So you can actually burden the right by saying Lindsay Hecox has to actually submit testosterone tests or something else different than other people, and that would not be allowed if it were strict scrutiny.
And if we follow your approach, which allows a challenge to even a fairly small group that's affected, in what way would we not? That would apply across an entire range of things where there's a distinction currently between boys and girls, quite apart from just athletics. Is that correct?
Your Honor, I do think that the question would, I think we're not trying to invent something here. I think we were trying to draw from what we understood to be precedent from the court, and I would direct you to the Equal Protection Scholars Brief. They have some scholars that have actually focused on this question of what does an as-applied challenge mean in the equal protection context. But I think taking a step back, the question always would be looking at what the state's asserted interest is here. And here the state is not asserting an interest of having the boys' teams be better and the girls' teams be worse. What they're trying to do is control for a sex-based biological advantage. And so I think a lot of the hypotheticals that you can maybe understandably think about, what about the untalented cisgender boy? What about the transgender woman who didn't mitigate? You know, what about this or that? That gets taken care of because the testosterone is the advantage on this record, and almost all the people that might want to try to get an as-applied challenge under some other idiosyncratic framework would not be able to show that their exclusion actually was.
Okay, and this will be my last question. My point was more that how we approach the situation of looking at it not as boys versus girls, but whether or not there should be an exception with respect to the definition of girls. That would, if we adopted that, that would have to apply across the board and not simply to the area of athletics.
I mean, I think it's a general framework for equal protection challenge that, again, predated this case, this litigation. There have been boys that have tried these challenges in the past. They generally have failed because they actually don't lack the opportunity or actually are treated, they're not being treated differently than similarly situated individuals.
You said, Ms. Hartnett, that you're not talking about individual by individual by individual. It has to be a defined group. So how big does the group have to be? How does it have to be defined? And why are there those requirements? If what you're saying is right about equal protection law, why wouldn't it extend to individual by individual by individual?
I don't think the court has foreclosed that other than this actual obvious conceptual question of like, when do we get towards strict scrutiny? I think what I could tell you is that in the way that the court looked at it from Caban to Lair to Nguyen to Morales-Santana and then also Trimble and Lally for the case of non-marital children, the court seems to usually be trying to figure out not just is this individual somehow idiosyncratic, but are they part of a group that actually doesn't make sense to exclude? And that makes sense because usually you're trying to figure out is the interest served by the exclusion, and there's usually some principle why a subgroup was not properly included.
And what are the requirements of, what does that group have to look like? Mr. Mupon suggested that it has to be, fairly sizable. It can't be 1% or less. Why not? Why? What are the other requirements? Like, how do you go about defining which group, which subclasses get to make this challenge and which subclasses don't?
That's a good question, Your Honor. I think in Trimble, this is again the non-marital children case and cited in the BPJ brief, they said discrete categories that were unnecessarily excluded. That was the notion there. So I think that's where we were trying to make clear that we don't think it can just be we have a person that is extraordinarily idiosyncratic and they should get their case. And I don't think anything in your cases rules that out. I guess that's not actually the case presented here. We think we have an easier case because we actually have identified a discrete subgroup, transgender women who do not have an athletic advantage.
But I don't think you're answering Justice Kagan's question, which is fine if you buy into you have this subgroup as you've identified it. Mr. Mupon says that subgroup has to be big enough. Do you agree? And if so, how do we evaluate that?
I don't agree with that. I think that is I think in a way this is the Caban dissent kind of coming back after many decades because there, Justice Stevens said in the dissent, he's assumed that the case in that case was assuming that the case extended only to himself and by implication to an unknown number of fathers, and went on to say indeterminately small part. So I think there's never been a numerical requirement. It's more of a question of whether there's a principle that some sort of a principle that allows for the exception in light of the failure to align with the interests that the state's asserting. And here, I think the record, and again, we're at a preliminary injunction stage, but the preliminary record was that the exclusion of our client actually was not going to advance the interest, nor the exclusion of other transgender women who do not, who have taken efforts to mitigate their testosterone, which was on the record here again, was the main driver of differential athletic performance.
Counsel, One might wonder whether the efforts to refashion our equal protection jurisprudence here that we've been discussing at length on sex discrimination is really a fallback from what one might wonder might have been your primary argument, which is that transgender status is itself a discrete and insular class. And I'm curious why you haven't brought that up and what thoughts you want to share with us. Your friend on the other side said the laws you pointed to in your brief don't address transgender persons as such, and that makes all the difference. Thoughts?
Well, thank you for the opportunity to address that. I think we were trying to find the most straightforward way to help the court to an answer here, and I think we do think
I've been wondering what's straightforward after all this discussion.
No, I understand. I think these are older cases, but it's very interesting to see the debate between the majority and Justice Stevens, and Justice Stevens and O'Connor kind of admitting that he was applying his dissent in Caban. So these are cases from the court. We think they have some force. But to the question you've asked, I do think it's important to begin with, you heard my friend on the other side talk about cross-dressing or other laws. They didn't have any response to our point, because there isn't one, that transgender people were categorically excluded from immigration to this country under an overall umbrella of being a psychopath. That was the actual decision of this court in the Boutelier case. It was an interpreting language of Congress that determined that when Congress used the term psychopathic personality to exclude people, they meant to include homosexuals and other sex perverts.
Perhaps and not our finest hour.
Well, it's not your fault, but I think that.
Thank you for that.
No. Well, it was by reference to a congressional report. They were trying to figure out what did Congress mean, and there actually was a public health service report. I would direct your attention to it because I think it really does go to the level. I was surprised when I read this document. It's 1952 USCAN 1653 at 1701, trying to explain why sex perverts would include homosexuals, transvestites, which was the name of the day for transgender people. The term transgender did not become more common till now. So I think reading Boutelier and reading the USCAN that's cited in Boutelier is instructive. I also think that the laws on cross-dressing, I think that's an interesting point, because what that actually means as a practical matter for the transgender person was that they weren't allowed to leave their home as themselves to enjoy all of their civil rights. And I don't think, we don't want to exaggerate it, but we also don't want to understate it. There were major cities in the country, Chicago, others, that actually barred you under subject to criminal penalty for leaving your house in clothes that weren't matching your gender. And people were actually prosecuted under those laws. So again, I appreciate, and we're not saying you have to have the same history. We're certainly not equating the experience of the transgender community to that of Black Americans or of women. But just as illegitimacy or non-marital children has been recognized as a class that gets closer look, I think we respectfully submit here it would make sense to do so. We appreciate, though, this is a question that the court hasn't recognized a suspect class for a long time. They also haven't shut the door to a suspect class since Cleburne. So I think we'd prefer, to the extent the court was still finding another path forward, the reason why we tried to help you find a way to answer the question here based on sex discrimination.
Well, to pick up on the issue of discrimination on the basis of transgender status, let me just go to some basics. Do you agree that a school may have separate teams for a category of students classified as boys and a category of students classified as girls?
Yes, Your Honor.
If it does that, then is it not necessary for there to be, for equal protection purposes, if that is challenged under the Equal Protection Clause, an understanding of what it means to be a boy or a girl or a man or a woman?
Yes, Your Honor.
And what is that definition? For equal protection purposes, what does it mean to be a boy or a girl or a man or a woman?
Sorry, I misunderstood your question. I think that the underlying enactment, whatever it was, the policy, the law, we'd have to have an understanding of how the state or the government was understanding that term to figure out whether or not someone was excluded. We do not have a definition for the court. And we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth sex males categorically from women's teams, and that there's a subset of those birth sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
I think here we just know we basically know that that they've identified pursuant to their own statute, Lindsay qualifies as a birth sex male. and she's being excluded categorically from the women's teams as the statute. So we're taking the statute's definitions as we find them, and we don't dispute them. We're just trying to figure out, do they create an equal protection problem?
All right, suppose this school that has a boys, let's say, track team and a girls track team. The school has that. And a student who has the genes and the reproductive system of a male and had those at birth and has never taken puberty blockers, never taken female hormones, never had any gender altering or affirming surgery, says, nevertheless, I am a woman. That's who I am. Can the school say, no, you cannot participate on the girls' team?
Sorry, so you're just a birth sex male who has all the advantages of birth sex male hormones, and can the school bar him from the women's team? Yes, they can.
But that person, is that person not a woman in your understanding? If the person says, I sincerely believe I am a woman, I am in fact a woman. Is that person not a woman?
I would respect their self-identity in addressing the person, but in terms of the statute, I think the question is, does that person have a sex-based biological advantage that's going to make it unfair for that person to be part of the women's team? And that's the rationale for the regulation, and so that's the way we would be testing that hypothetical.
Well, the reason I'm asking has to do with discrimination on the basis of transgender status. So what you seem to be saying is, yes, it is permissible for the school to discriminate on the basis of transgender status, because if this person is a trans woman, a trans girl, and is barred from the team, from the girls' team, then that person is being subjected to differential treatment based on transgender status, right?
Well, that would be, then the question would be whether it was, the scrutiny would be satisfied. So from our perspective, that would be a transgender classification. It would get heightened scrutiny, and it may be satisfied here because of the need to have, to curtail unfair athletic advantage. That would be the analysis. We are not pressing in this case the notion, and the case does not require the court to decide whether transgender women who've gone through puberty and have not suppressed their testosterone would be able to play on a men's team. And the record here is a preliminary one where that doesn't present that question for the court.
When this does present a particular factual situation, and we have to decide that case, but looking to the broader issue that a lot of people are interested in, there are an awful lot of female athletes who are strongly opposed to participation by trans athletes in competitions with them. What do you say about them? Are they bigots? Are they deluded in thinking that they are subjected to unfair competition?
No, Your Honor, I would never call anyone that. And I think what we're saying here is that you have to, that's the reason why there is intermediate scrutiny, or even in rational review, you don't legislate based on undifferentiated fears. You base on trying to make a rational response to what is a perceived issue. I think here, although I would take issue with the notion that there was no reference to transgender individuals in the creation of this law, I really would direct the court to JA. Again, this is not about animus. I'm just saying that if you look at JA, pardon me, I need my JA 105 through 112, there are numerous references from the sponsor of the law saying the way we're going to try to protect women's sports is to not have transgender women play on the women's teams, and that was the fear that they had at the time. Again, that is not an accusation of animus. It's just a question of what was the statute doing, and then we go to the point of, does the statute survive heightened scrutiny? That would be the inquiry.
Do you think that the success of trans athletes in women's sports is proportional to the percentage of trans athletes who participate in women's sports?
I think I would direct your attention to, there's a, I want to make sure I have the right amicus. There's an amicus brief that talks about actually some of there are examples, obviously, of some transgender people that have participated and excelled. They actually are few and far between. You know, we have our client here who tried to make the NCAA team because of the injunction. She was too slow. She played club soccer, club running. She was even an officer in one of those clubs, just doing what you would hope a college student would do. You'll hear from my colleague about the other case. But I do think that, and there's a brief that in the amicus briefs that will share the examples of showing that's a bit overstated.
Would the analysis be different if they were more successful?
No, I think it would be, to the extent, I mean, we've already covered that transgender people are a meaningful slice of the population, but a small slice. I think the state, if there were a concern of women's sports being fully overrun by an outbreak of a huge new number of transgender people, that might be a different factual situation. In the end of the day, and we understand that there were legislators who were concerned about that. The legislative history makes that clear here, but that wasn't the factual basis before the court. If there were actually a threat to women's participation in women's sports, that could be a different analysis, because obviously the goal of sex equality in sports is a very important goal. We don't take issue with that. We just would say that I think this is an important moment to just take a step back and say, is this law actually responding to a problem in a rational manner, or is it actually overreacting on the presumption that transgender women are categorically going to be strong athletes when that's not the case?
Well, just to put the big picture, and you know this, on the table, and let you respond to it, but obviously one of the great successes in America over the last 50 years has been the growth of women and girls sports, and it's inspiring. And there's some states in the federal government and the NCAA and the Olympic Committee, so these are a variety of groups who study this issue, think that allowing transgender women and girls to participate will undermine or reverse that amazing success and will create unfairness, because you said if large numbers, well, for the individual girl who does not make the team or doesn't get on the stand for the medal or doesn't make all league, there's a harm there, and I think we can't sweep that aside. And I think that's what's undergirding some of the concerns, big picture, and there are harms on both sides. So I completely understand that, but I just want to let you respond to that, because that is, the NCAA, the Olympic Committee, a lot of states, federal government, that's a lot of people who are concerned about women's sports and think this raises a big problem, and I just want to make sure you can explain that.
Thank you, Your Honor. And just to be clear, Title IX is a huge triumph, and I'm a veteran of women's sports myself. I'm glad it exists. It's made a huge difference in our society. That's not what we're talking about here. But I do think, to the point of, for the podium question, I think the question is there an unfair biological advantage? That would be the question. So I understand the point. If there is somebody who's coming in with an unfair biological advantage, that would undermine the entire point of separate sports in the first place, which was to allow women to have a place to thrive, to be strong, to win, not to just be the B team. The question in this case is if the person had actually mitigated their sex-based advantage, which maybe interestingly, maybe counterintuitively, actually is more about circulating testosterone after puberty than a lot of the other things we might think are sex-related, then that girl that's come in second to a transgender person that's mitigated actually may just have come in second because the transgender person was similarly situated, but was stronger in that one competition. That's why we are here not proposing a rule of absolute inclusion, but saying that in the case with people like our client who have mitigated, their exclusion doesn't match the statutory interest.
Counsel, can I ask you a question about analytically in the discrimination on the basis of transgender status? Since trans boys can play on boys' teams, how would we say that this discriminates on the basis of transgender status when its effect really only runs towards trans girls and not trans boys?
We understand the point, and I think that might be relevant to for example, animus point, right? There were not a complete exclusion of transgender people, there was an exclusion of transgender women. But I think on that piece, this court has never required the whole class to actually be excluded to look at the cases to whether the exclusion of a subclass was
I'm talking about for triggering intermediate scrutiny if transgender status is a suspect class.
Right, so like Craig B. Bourne, for example, that's the one about the men that couldn't get the 18 to 20-year-olds, right? That wasn't all men, it was a subset of men, and yet the court still viewed that as a sex classification subject to heightened scrutiny. And likewise here, even though it's just transgender women, in our view, that are being barred and not transgender men, that also would trigger heightened scrutiny. And I think there's the Rice v. Cayetano case from 2000. There's other examples of the court making clear that just because a subset of the protected class is being excluded, you still would apply heightened scrutiny.
Another question about the science. So you were talking about circulating testosterone being kind of the marker. Idaho is saying, well, that's not the only indication. There are other, when I asked the question about 6-year-old teams before that there are other just kind of genetic hardwired differences, maybe in size, et cetera, that don't have to do with circulating testosterone. Is it your understanding that testosterone is it?
And my colleague who will present the argument in the next case, that the record there was more about prepubertal and puberty. Right. I think that the 5% even is not clear whether that's just environmental or biological, actually.
Right.
But I do think, so there are other things that I think, like height, bone size. There have been some other discussions of this. This is an underdeveloped record, by the way. This needs to go back and have a full trial, except that it's moot. But I think the point there is that, no, I'm not trying to make a point on that. I'm not trying to pretend that I'm going to have a trial when we're not. But I think the point is that sometimes counterintuitively, it's like having a larger frame, but not having the muscle and the testosterone to drive it could actually put the person in a worse position. And that's a study that was commissioned by the Olympic Committee. It's footnote 6 of our brief, indicates that actually it could be put the transgender woman at disadvantage if they happen to have larger bones and less testosterone or muscle to drive those bones.
Last question. So below, as I understand it, your client challenged the verification procedures.
Yes.
Except when we were talking about how this might be administered, I understood you to say that it would be by checking testosterone levels, because it would be okay to say, to Justice Alito's hypothetical about the cisgender male who has taken no steps and who is now trans, to exclude that person. But would that be an invasion? Would that be a violation itself, or too invasive to require someone to, and maybe not just once, but maybe to periodic testing to make sure that the circulating testosterone was low enough? Why wouldn't that be invasive?
So that's an ordinary blood work that a transgender person would get, and that's why I think it's of the nature of the minimal burdens, like in Nguyen and the other cases where the court has said intermediate scrutiny applies, and you actually can, if there's minimal things you have to do to make yourself fall in the category that we want to keep protected, we can require that of you. But
didn't you challenge it?
Well, that was different actually, because the 3 things that you'd have to prove under the state's novel verification thing would have to be your genetic, your reproductive anatomy, which would require actually like a pelvic examination or examination of someone's, nude area. It would be chromosomes, which would require chromosomal testing. That's not what we're talking about. Or it would be endogenous testosterone. And the reason why that wasn't a problem is not because of a blood test. It's not invasive. It's because it would have required the transgender person to stop their hormone treatment to get back to an endogenous level to be able to show they're endogenous.
Okay, so the distinction between circulating and endogenous.
Right, the point was that was actually in a way, like, and I'm not trying to cast aspersions, but kind of a false requirement for transgender people, because they aren't on their endogenous testosterone when they're on hormone therapy. They're on a non-endogenous medical treatment.
Thank you, counsel. Justice Thomas? Justice Alito? Sotomayor?
I'd like you to address mootness, because you raised it with Justice Barrett. Is this case moot? Could you respond to the other side's positions or arguments as to why it wasn't? And how do you respond to that? Secondly, Justice Barrett did raise earlier, this law applies even to primary schools, correct?
Taking your second question first, yes. I don't think it's in the record whether or not there are any primary schools, whether they sex separate or not, but that is the law.
And so, at least as to that subgroup, no one could doubt that primary school children might have the strongest argument that there's no difference in their physical makeup that would cause harm or otherwise create an advantage, correct?
That would be our position, Your Honor. In this case, we had both our client who was at college at the time, and then we had a high school intervener who was worried about being subject to the sex verification, so we didn't really get into the building a record on the
But the point is that the law might be overbroad in many ways.
Certainly, yeah.
And there's still, as you noted, Idaho is the first or the second state to pass this law?
It was the first. I mean, these cases come to you because they're early ones.
And the record here was the most underdeveloped, correct?
Including because it was a preliminary injunction. There was a substantial amount of expert material in the record that allowed the district court to make appropriate findings, but it was not the level that you build out for a trial.
And both courts said that the record had to be looked at more carefully.
Expressly, they did.
All right, so answer the mootness question.
I mean, Your Honor, all I can say is that we've tried to provide the court with accurate information as soon as it came to pass. In 2024, when we opposed certiorari, our client still was active and intending to play sports. The court granted the case. She was preparing for what she hopes is her final year of college. She was concerned about the increasing hostility and the visibility. I mean, we're here now, and that's okay. She understands she brought the case. But that was the basis for her trying to end her sports career. And it isn't contrary to what she said before. She did intend to play sports through college. Her college has taken a long time. She's now sworn she will never play sports that are covered again, and she won't do that even if she happens to somehow win this case. So that is just the truth. But whether the court believes it's moot, that's, we put the facts before you for you to decide.
How about her graduating this year? There was a suggestion she might not.
As you can tell, we have, college students have so she is trying her best to get through college. I think at this point, and I'm just basing on what I know of as to today, she's unlikely to graduate by May, as my friend said, but is hoping to make through summer credits, could graduate in the fall.
Finally, in terms of the sports teams, the Olympic team, that all happened in 2025 after our president directed them to.
We do think that's worth parsing out. Again, there's been a lot of contentions made on both sides that are extra record, but I do think a lot of those things flowed from the executive order. There were some other sports orgs that were doing different things, but I think we have to be careful not to broad brush that because some of it may have been political, some of it may have been scientific, and the record really isn't fully before the court.
Justice Kagan?
Ms. Hartnett, I just want to get your understanding of what constitutional review would look like in this context. So you said it's not individual by individual. You have to come in and say there's a class that's not being treated appropriately. What is that class here?
Thank you, Your Honor. And I would say I don't think the court has ruled out the individual case. I just think we weren't presenting it that way because we were trying to align ourselves with how the court had looked at it. I think we would say we represent the group of people that do not have an athletic advantage, that have mitigated their their biological advantage of being born male.
So who do not have an athletic advantage, I mean, for reasons of taking certain medications or hormones or
no sex-based biological advantage. So it would encompass both people that had gone through the male puberty and had mitigated. It would also encompass others that have not yet gone through puberty or that staved off puberty with the puberty blockers.
And as to those people, who has the burden of showing that the justification doesn't fit?
I think I think once we've identified the subclass under intermediate scrutiny, it is the state's burden to show a substantial relationship for that group, and they failed to, and that's how those other cases proceed.
You wouldn't think that because we are talking about an as-applied challenge to a law that's facially everybody can see is legitimate, that the burden should shift to you?
I don't think that's how the cases looked at it when they were assessing. They were kind of assessing whether the state had provided enough to allow the exclusion. For example, in Lair, the state had made an adequate showing to show why the parent in that case was properly excluded.
And how do you think the question of scientific uncertainty should play out in an analysis like this?
Thank you. That's a good question, and I know this was something the court did address in Scrimeti, a rational review case, but citing Carhart, which also talked about that. I think the one thing we definitely want to have is complete findings, so that's why we really were urging to have a full record developed before there were any final judgment of scientific uncertainty. I think the court has not fully grappled with what does scientific uncertainty mean and how does it come into conflict with heightened equal protection scrutiny, but I think we don't need to present that yet because on this record, there was not uncertainty. This person had mitigated, testosterone was the determinant. Maybe on a later record that would come out differently, but I don't think that.
Just play it out a little bit if there were scientific uncertainty.
I mean, if it really were an equipoise, then I think that that is a situation where I think it's still heightened scrutiny. So under heightened equal protection scrutiny, the burden is on the state to justify the law, and if they haven't been able to justify that, that usually fails. If it's really a question of they're at 50-50, do we allow the state some leeway? I don't think that's been answered in the court's cases. Normally, the heightened scrutiny controls, and there's not a deference on top of that in the equal protection context.
Thank you.
Justice Gorsuch.
Just to follow up on that, I wonder if that starts to sound like strict scrutiny, because if the point of intermediate scrutiny, of course, is some leeway for the state, not a perfect fit, at least in the facial area. But if there's scientific uncertainty about whether puberty blockers and testosterone suppressants completely or mostly or some percentage of the time eliminate all competitive advantage, some competitive advantage. I mean, you've been very careful, I think, and rightly so, to talk about mitigating advantage. But I don't know, does the state have to show that it eliminates advantage and it doesn't eliminate, some percentage of advantage remains in each individual case, or for the group as a whole, I'm struggling to understand your response to Justice Kagan on that score. Maybe I'm inartfully posing the question, but I hope you understand.
I do understand your question. I think the question is at some level, I mean, I think the question is where you have science that's developing in real time at some level, what happens, how does that dovetail with trying a state that's trying to regulate and do that? I think what we can say on this record is that categorical exclusion is really not supported, I don't think, by any science. This again was from kindergarten through college. And so there'd be some subgroups at least. And I think there has to be an effort to try to tailor it. I think here the problem was there was a reaction of transgender women, a picture of what that would be, kind of an undifferentiated fear, frankly, from the Cleburne case. And so I think
I appreciate all of that, but it seems to me from my glance at the record, and quite a record it is, and, that there is a healthy scientific dispute about the efficacy of some of these treatments, and that's understandable. And I'm just wondering, how does that fit with, assume there is some dispute, and I understand the record remains to be developed further, but how does that fit with intermediate versus strict scrutiny?
At the end of the day, it's the state's burden to show a substantial relationship, and I think in the case of something where they're doing their best and have the best evidence some evidence to support what they're doing.
Some evidence, the best evidence, exactly. I mean, that's
a level of evidence that wasn't met here. So the study and the findings. I mean, the district court made a really good point. That study had actually been retracted, and it didn't pertain to transgender athletes. So in a way, this is not the hardest case. I appreciate it as a hypothetical. I guess what I would just urge in this area that's sensitive, obviously politically, but also as a matter of science, to at least let a record develop in one of these cases that lets you decide, actually, is this
I totally agree with that.
50-50 versus 80-20?
All right, but 50-50, does the government win? Does 70-20 the government win? That's what I'm getting at. I understand the complexity of the record and the difficulty of the science, but if we're going to have individual cases brought, that's the kind of question we're going to ultimately have to answer. Not the science question, but the percentage question, if you will.
No, I understand that. I mean, VMI does provide some sort of a metric of what we would do there, which was we looked to see there were kind of evidentiary debates on both sides of that. But even if you could say that a lot of women may not have ever made the cut, the fact that there were some that did was enough to invalidate the entire policy. So I think there are ways for courts to make those judgments, and I think the court has not yet, I think, encountered a case where heightened scrutiny puts a heavy burden on the state. It's not an insurmountable one, like strict scrutiny normally is. And then what happens if it ends up with the evidence being a tie or close to it when we go back to the trial court? I think that would be that would be breaking some new ground, because I don't think there's an equal protection case that decides that issue. Usually the evidence is kind of clear on one side or the other about whether the restriction is justified.
That would remain for us to decide at a later point.
I do think that's the most prudent, but definitely on a record that's more developed, because I think I think in the end of the day it might end up being a surprise to, we don't know yet, but I think we have some good evidence that actually at the end of the day, being a transgender woman, actually to the extent there are, and you've repressed your testosterone, you're at somewhat of a disadvantage in many ways, because you have, again, this larger frame with weaker muscles and no testosterone.
Thank you.
Justice Kavanaugh?
Just to follow up on Justice Gorsuch's question, a broader frame about the role of this court when there's scientific uncertainty. I mean, there'll be different district courts who do different things, almost certainly in different cases, and in an area of scientific uncertainty where there's strong assertions of equality interests on both sides. And so it's going to come to this court, and we have to decide for the whole country, constitutionalize this. And I guess given that half the states are allowing it, allowing transgender girls and women to participate, about half are not. Why would we, at this point, just the role of this court, jump in and try to constitutionalize a rule for the whole country while there's still, as you say, uncertainty and debate, while there's still strong interest on the other side? And I think one of the themes of your argument's been the more people learn, the more they'll agree with you. At least I've detected that theme in your argument. So why would we get involved at this point and constitutionalize?
I understand the question, Your Honor, and I do think that the Equal Protection Clause's demands have never been viewed as kind of a separate avenue from the legislative process. They can and do often coexist. And here, I think the point is we have two as-applied challenges to early laws. They have their unique cases in their own right. I don't think this court needs to set rules forever on this area. I think the most important thing would be to allow a record to develop, even in areas of controversy. And we look back at what you cited to in Scrimeti, you cited Carhart. There were extensive findings. There also were findings in VMI. There were findings in Craig v. Boren. I'm learning things by reading these cases over again. There were findings in those cases. And so I think that at least before the court decides to either step back fully or to embrace its role here of providing the scrutiny that should be attended to groups when there's a worry that the democratic process isn't actually going to fairly respond to their concerns, I think the point, at least at a minimum, would be get a full record, which we don't have here. That would be my request.
Thank you.
Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal?
Thank you, Mr. Chief Justice. A few points. I heard just a moment ago that there is no real threat to women's sports. We strenuously disagree. We cite your honors to the UN Special Rapporteur's report that says 600 women have lost 890 medals in 29 different sports. That's what we're talking about. It is a real threat. Medical transition does not reliably suppress all male athletic advantages. I'd cite your honors to our record in which our expert, Dr. Brown, shows the experience of one C.C. Telfer, an elite track athlete who underwent a medical transition and whose track times did not change. That is the story in many situations, and unless we can reliably distinguish between those situations and the situations which testosterone suppression does reliably eliminate the advantage, then we can't do that. We need a broader classification, and sex is the right one. And if it were merely politically motivated, I would add we wouldn't see this same rule being implemented by World Athletics, World Boxing, the NAIA, these different groups that were not influenced by recent politics, but came to these decisions after studies, after lengthy examination, and reached the same decision that Idaho has. Justice Gorsuch, in your colloquy with Respondents' Counsel, she agreed with us that this is not the same as the discrimination that has been faced on the basis of race or on the basis of sex in this country. We agree it's not close to the discrimination that people have faced on the basis of race or sex in this country. That said, the court does not need to reach that answer here, because if there is no transgender status classification in Scrimeti, there certainly cannot be one in this case. In fact, as our briefs argue, the court can and should avoid all of these questions by applying rational basis review. Bottom line, sports are assigned by sex because sex is what matters in sports. It is the fairest and the safest and the most administrable way to assign sports teams. It's been widely accepted for many decades because it's necessary for fair competition, because where sports are concerned, men and women are obviously not the same. If Idaho can't enforce a sex-based line here in sports, where nobody disputes that biological differences matter, then no line based on biological sex can survive constitutional scrutiny. The court should uphold the Fairness in Women's Sports Act and reverse.
Thank you, counsel. The case is submitted.
Ladies and gentlemen, you are changed to the second case. Please remain seated.
Argument next in case 2443, West Virginia versus BPJ. Mr. Williams?
Mr. Chief Justice, and may it please the court. States have long assigned students to sports teams by sex. West Virginia is no different. Maintaining separate boys and girls sports teams ensures that girls can safely and fairly compete in school sports. The question today is whether this enduring structure can continue. It can. Title IX permits sex-separated teams. It does so because biological sex matters in athletics in ways both obvious and undeniable. The text, history, context, and structure of the statute, alongside regulations expressly authorizing what West Virginia has done, confirm as much. Respondent says that West Virginia schools can no longer designate teams by looking to biological sex. Instead, schools must place students on sports teams based on their self-identified gender. But that idea turns Title IX, a law Congress passed to protect educational opportunities for girls, into a law that actually denies those opportunities for girls. The court should not embrace that backwards logic. Aside from its problems with Title IX, the decision below constitutionalizes one side's view of a hotly disputed issue. But West Virginia's law does not offend the Equal Protection Clause either. The West Virginia legislature reasonably and rationally defines sex based on biology and acknowledged the physical differences that biology creates. Given those differences, the law satisfies rational basis review. And the state's law satisfies even intermediate scrutiny because it is substantially related to the important governmental interest in ensuring fairness and safety in girls' sports. Respondent attacks the law by searching for a transgender classification that simply isn't there. The law is indifferent to gender identity because sports are indifferent to gender identity. Ultimately, West Virginia's law, like the laws of at least 26 other states, simply preserves the enduring structure on which girls' sports depends. It should be upheld. I welcome the court's questions.
What's your view of with Title IX, how it defined the separated sexes, male and female?
So under Title IX, Your Honor, we would look to the ordinary understanding of sex at the time that Title IX was passed, 1972, and I think also relevant would be 1974 when the Javits Amendment was passed. And at that time, the ordinary understanding of sex was biological sex, consistent with the understanding of sex reflected in West Virginia's statute. I think that's also consistent, frankly, with this court's own understanding of sex and some of its own cases like Frontiera, where it likewise focused on things like reproductive function.
Well, with that definition, how would you square this challenge with the continued existence of Title IX?
So I think this challenge fails under Title IX, and in fact, it amounts to a backdoor attack on Title IX, in the sense that Title IX itself contemplates sex distinctions, and express regulations specifically applying to the context of athletics expressly contemplate the distinctions between sex of male and female sports teams.
In interpreting this definition, would it make a difference, or does it make a difference that this is a spending clause statute?
I think it absolutely does, Your Honor. Obviously, in the spending clause context, as this court has somewhat recently reminded lower courts, it's important for Congress to speak with an even clearer voice because of the contractual nature of the conditions that are imposed. States like West Virginia have to understand exactly the obligations that they're assuming in the context of a spending clause analysis. And so it amounts to effectively a canon of construction that requires that clearer statement in order for the condition to attach.
I would have thought that's an interesting argument, that this is spending clause legislation in Title IX, and Congress has to speak with a particularly clear voice, and whatever it's said here isn't clear enough. You didn't raise that argument. And there's an argument from your friend on the other side that you waived the argument, or forfeited it at least.
Right.
And it sure isn't the lead argument in your brief. Help me out. Why?
So we, of course, start with the plain text of the statute, Your Honor, as this court has told us to do several times.
Yeah, well, I might start with the constitutional authority under which that statute was adopted. counsel.
I think that's equally compelling authority for our understanding of the
Equally compelling, the Constitution equal.
Perhaps greater compelling
I would
authority.
have thought, yeah.
West Virginia, as you know, I think...
Why isn't it in your brief?
West Virginia is maybe uniquely a fan of clear statement rules, as Your Honor might know from past cases, but in the spending clause context, I think it is in fact the case that your court has repeatedly stressed that Congress has to speak with that exception.
I know what we've said. I'm wondering about what you didn't say.
So I think if you're looking at the way that West Virginia has characterized it, certainly we have made that argument and presented that argument to this court. I'd refer you to the topside brief. It's clear and centered under a clear heading. As I think what their suggestion is from the other side is that we didn't clearly enough raise that argument below. We would take issue with that characterization. There was obviously binding contrary authority in the Fourth Circuit. And so I think strategically we decided not to make that the front and center argument because we understood that was dead on arrival in that particular court. But that's not to say that we waived the issue by any means. It's a canon of construction that continues to assist this court in its application of the text of the statute.
But counsel, can I just ask you about this, though? Have we ever applied the spending clause's notice requirement outside of the damages context? Because here we're not talking about a situation in which BPG is seeking damages, and I thought that was sort of a crux of the spending clause analysis.
I will concede, Your Honor, that many of the cases that talk about this rise in the context of, or maybe even all of the cases that rise in the context. I'll concede as much, yes, Your Honor, but I don't think the court has ever suggested that the specific request for damages is the reason for its analysis, and I think that actually would be inconsistent.
But we would be having to address that, I guess, and extend it in this context if we were to take a spending clause tack.
I would respectfully disagree, Your Honor. I would say that just because the court hasn't done so before doesn't mean it's an extension per se. I think that what the court has said is that you view the language of these statutes as effectively contractual agreements. And I think that that same sort of contractual logic applies whether you're asking the state to pay out damages or whether you're asking it to take specific action under compulsion of that.
Who is the contract between here? And I thought the regulated party needs to know what it's agreeing to so it can consent, but here the regulated party is the schools and it's the state that's coming in. So I'm just trying to understand how the spending clause analysis works in this context.
So I think the state is certainly one party that does receive federal educational funds, but it's also the many other petitioners that stand before you, including the county school board and the state school board, are also petitioners in this case. I think there would certainly be, if anybody were clearly bound by the conditions of Title IX.
So it would map on, I mean, I guess I'm worried that this might actually implicate the question that we didn't resolve in Moyle, and so we'd have to kind of figure that out because it seems like it's a different set of facts than the typical spending clause application.
I think if anything, Your Honor, this is maybe easier than your typical spending clause analysis because you've got everybody from the state all the way down to the local county school board. Anybody and everybody who's involved in this case is a party to this action. In fact, you resolved a petition for cert from the Athletics Commission saying we're not actually a state actor, and the Fourth Circuit saw things quite differently. So I think there's really no concern in this case that you have an absent actor problem when it comes to the spending clause analysis. And ultimately, of course, if it's just a canon of construction, if you're looking for a clear statement, then I think it would apply regardless of the particular party who might be in front of you because the statute applies across the board. You know, the regulated party is going to be affected regardless of whether they happen to be in front of you in the given case.
Can I ask you
I'm sorry. I presume that if it's statutory construction, a canon of statutory construction, it's hard to say you can waive that?
It's very hard to say you can waive that, Your Honor, yes.
I just wanted to ask if, on your understanding of Title IX, you could have separated by sex classrooms in biology or math based on some evidence that you have that say men are better at math and science. What are the limits to your Title IX theory?
So I think your instinct there in part arises from the fact that we're skeptical of any notion that there are inherent differences. So I want to kind of acknowledge the real reality of this.
Well, your whole position in this case depends on there being inherent differences, right?
It does, and I think that that's exactly why discrimination in the Title IX context, where it acknowledges merely inherent biological differences, that's not discrimination, that's a distinction. And I think that's consistent with this court's longstanding understanding of what discrimination means. It looks to differential treatment of similarly situated individuals. So even in a case like North Haven, you're talking about differential treatment of similarly situated individuals. So if we're talking about in an athletic context, you're not addressing similarly situated individuals. And I think, again, the Javits Amendment and the regulations that flowed from the Javits Amendment are a realistic reflection of those meaningful biological
The
differences.
Javits Amendment gives you a reason in the sports context maybe
Right.
to do it. I'm just wondering whether, your friends on the other side have basically conceded that Title IX allows sex-separated sports teams. So I don't know that we need to really get into that. I'd be a little bit concerned about what the ramifications of that might be. And the Javits Amendment, in the context of sports, makes a difference anyway. But more broadly, I mean, if a state produced some studies saying, listen, women's presence in calculus is holding men back because they're so much more capable and they can just move so much more quickly, seems to me like there'd be some risk on your understanding that that would be okay.
I think, again, realistically, Your Honor, that would almost certainly fail on the lack
How
of...
about chess club?
A chess distinction, I think, again, might fail because there's an actual lack of evidence of meaningful physiological differences that are reflected in the existence of the express regulations in the athletics context.
I mean, I think a lot of people would say, if you look at the ranks of chess grandmasters, there are not a whole lot of women there. And, what does that mean? Well,
I think...
I think that there's a sort of intuitive... I think there are a lot of chess grandmasters who would tell you that women just, for whatever reason, they're not as good as this.
I think chess is an interestingly closer question. I've come to understand just recently, in fact, that there are sex distinctions
Well,
in the elite.
you're fighting the hypothetical, and I guess the question really is, okay, Title IX says you can't discriminate on the basis of sex.
Yeah, sure.
I understand what that means. I think I do, right? Can't treat men and women differently. Okay, all right, fine. You're saying, but it matters whether they're similarly situated, and your friends in the government like that line too. Well, there's, I got a lot of evidence that girls perform a lot better in high school than boys. Okay, there's a lot of scientific evidence, whatever, or just posit that, all right? Well, so I'm gonna have a special remedial program for boys, and the women can't come. And because they're not similarly situated. Why on earth would Title IX care about that? It says you can't discriminate on the basis of sex in a program or activity of your educational institution.
So I think...
Why put that gloss on it?
And Your Honor, I want to be clear. I think the task for the court today is somewhat easier in part because of the express regulations that they have actually not challenged and that do expressly contemplate exactly what West Virginia has done. So I think your hypothetical, yes, of course, is there, but I think the reality is that Congress and the agency have together kind of addressed this specific question in a way that makes this court's task much easier. But I think the problem may be with
Maybe another answer, we don't need to rely on this similarly situated argument? Is that what you're trying to tell me, counsel?
I think you could also take that approach, yes, Your Honor. And I think the reality is that that hypothetical addresses a situation that's much closer to the sort of exclusion and the specific context that gave rise to Title IX in the first place. And so I think that the court would be much more legitimately concerned that that would detect the very problem that Congress is trying to head off in passing Title IX in the first place. But I think that really kind of puts the lie to the position that West Virginia is somehow discriminating because it's advancing the very same purpose that Congress itself was trying to advance in enacting Title IX in the first place. I mean, that's why West Virginia somewhat deliberately made its law mirror the exact same language from the express regulations themselves.
I'm afraid I've got one more question. I'm sorry. Please go ahead. No, you're...
I can do both.
No, you can't do both. That's not fair. That's not fair. I mean, even by our standards. You make the argument that on the basis of means solely because of. Solely. We have long said that because of means but for, not solely because of. The Rehab Act speaks of solely because of. It seems to me an awful big stretch, counsel, to say that on the basis of imports anything other than but for causation. And, Comcast is against you there. And I just wonder why you put your eggs in that basket.
So, 3 answers, Your Honor.
And by the way, isn't the distinction here solely because of sex anyway?
Well, let me take each of those in turn, or I'll try. I don't think that the case turns on the court accepting the idea that it's solely on the basis of sex. So I think you could stop.
That's a sufficient answer right there.
Fair enough.
Thank you. Your turn.
Thank you.
Can you explain the relevance and significance of the Javits Amendment to distinguishing sports from all these other hypotheticals?
So I think the relevance and significance is Your Honors are faced with a unique set of regulations in that Congress was directly and intimately involved in both the instigation of the regulation in 1974 and then sort of...
And in that law referred to the nature of particular sports, right?
It did. So what they said was, we want you, the agency, Hugh, to go ahead and implement Title IX writ large. And it called out one specific problem that I think arose on the floor about whether Title IX applies to intercollegiate athletics, in particular intercollegiate athletics. And I would say...
And that's been extended to high school by the regulations. But,
exactly.
But ruling for you on sports does not open the door, in my view, given the Javits Amendment, to the chess club necessarily. That could be separately analyzed, but it doesn't follow from a law that says sports.
That's exactly right, and that's exactly why we were trying to make your job easier in the sense that we took the language expressly from the regulations and mapped it over under our own statute. So there's really no debate. If it's outside the context of Title IX, it's outside the context of our statute. So at that point, the court's analysis is done. But I think when you have a regulatory scheme where Congress was specifically involved, in fact, undertook a review, then that's exactly the sort of regulation that even in a post-Loper Bright world continues to have importance because it's long-standing, continuous, contemporaneously issued, all those sorts of check boxes that this court under a Skidmore framework continues to place substantial weight on. So I think that makes the court's task relatively straightforward.
And what about Bostock?
No.
You want to deal with Bostock?
I think, so I guess it depends on the way in which you mean it. Does it deal in Bostock?
If an employer said we're going to fire all the transgender women, that'd be a violation. If a school says we're not going to allow the transgender women to play sports, you say that's not a violation. Both statutes use the term sex. Can you explain?
I think the reason why is, well, to be clear, our statute is very different from a specific choice to say a transgender person shall not participate because of their transgender status. And I think that really is what makes the difference between this case and Bostock, is Bostock is attacking status-based discrimination, and West Virginia would, I think, be in a much different position if we had just said transgender persons shall not compete. But that's not what West Virginia...
What if it said transgender women and girls shall not compete in women's and girls' sports?
I think, again, that's a much closer question. I think if we're talking about engaging with the actual status...
You think you could lose under Title IX with a statute that said that?
I think Bostock, is, now I understand Your Honor's question. I think Bostock raises an interesting question as to whether that reference to transgender status would in turn implicate the sex status that Title IX is meant to address. But ultimately, I think the court doesn't need to address that because you can stop at the first step, right? You don't have an actual transgender exclusion that would give rise to that kind of linkage of analysis.
Thank you, counsel. In terms of Bostock, I understand that to say that discrimination on the basis of transgender status is discrimination on the basis of sex. But the question here is whether or not a sex-based classification is necessarily a transgender classification. And I wonder if that is consistent with your understanding.
It's entirely consistent. I would say on the equal protection side in particular, and also in the Title IX context, I think for some of the reasons I just discussed with Justice Kavanaugh, I think the court can stop and say that a sex definition and a reference to biological sex is not the same as a transgender classification. And I think even if we engage in the sort of but-for causation analysis, I think it's as simple as saying, does the result change if you change the gender identity of the individual involved? And the reality is, if you apply the West Virginia statute to someone identifying as a biological boy identifying as a boy, applies in the very same way as a biological boy identifying as a girl.
Justice Thomas? Justice Alito? Justice Sotomayor?
I find it strange that the district court and the court below did find a Title IX violation, but not an equal protection violation, and remanded for the equal protection violation. I'm not sure how it could do that, because it would seem to me that if the evidence is not sufficient to justify finding an equal protection violation, it's not sufficient to find a Title IX violation. Is that correct? At least on the record as it exists now.
Right, and so to be clear, the district court actually ruled for West Virginia on both Title IX and so the Fourth Circuit said, you lose on Title IX and we're not sure about equal protection.
But assume the Fourth Circuit is right.
Right. Well, so in answer to your question, I think that doesn't make sense. And I think the reason why it doesn't make sense is because the Fourth Circuit effectively stripped out what they said is Title IX doesn't leave room for any kind of justification or any kind of analysis of what the reasons might have been for the state's action. And I think respectfully, particularly when you look at the regulations themselves, that actually does contemplate exactly that sort of analysis.
I agree with you on the regulations. Right. And so could you not have a Title IX violation but still have, let's assume, and I know you're going to fight the factual premise.
I'll try to embrace it, Your Honor.
All right, embrace it. All the scientific evidence showed that there's no difference between cisgender girls and trans girls. I know there's a fight about it.
It hurts.
I know it hurts. But assume it. Could you not still have violated? Could we hold that as the regulation stands, the regulation would permit you to discriminate, but the equal protection clause would not?
So let me try to get my head in the framework of assuming. I think the regulation would still allow us, under its express terms, right?
I'm assuming,
right.
Yes.
And so you're asking, even assuming our compliance with the regulation, could we still have a potential equal protection problem?
Yes.
In that world, I think we would still be fine under the equal protection analysis, frankly, for some of the reasons that you heard from the solicitor earlier today, where it's because even if you assume the heightened level of scrutiny, let's assume that we're in intermediate scrutiny world, it's still a reasonable fit. It's not a perfect fit.
Then we're back to that.
Exactly. And
right.
I know we've had a long colloquy about that today, but ultimately I think that's what
I just destroyed that by saying that the science has said there's no difference. Well, and we know that's not true. Assuming the science said there was no difference.
Right.
How could you ever say it's reasonable?
So I'm assuming a world in which there's no difference between, so you're saying testosterone suppressed individuals? Is that?
No,
or you're saying all men and women full stop?
Right.
Oh, okay. I apologize for misunderstanding the hypo. If we're assuming a world in which there's really no biological difference, full stop, as to men and women, full stop, then I think, right, the legitimate governmental interest falls away. I agree with you.
Justice Kagan? Disagree? Justice Kavanaugh?
There are, as we've discussed, a bunch of states that allow biological males who identify as female, transgender women and girls to play women and girls sports. We were talking about that with the Solicitor General earlier. On your theory of Title IX,
right,
are those states violating Title IX rights of the biological females?
I think it's a much closer question under Title IX than it is under equal protection. And I think the reason being is that the regulations specifically say there's
well, what do you think the answer is under equal protection? I might as well ask that.
So under equal protection, I think we agree with our friends in Idaho that there's enough room for California to make a different determination.
Okay.
I think under Title IX, the reason why it's a closer question is because of the existence of the regs. And the regs start by saying you start with co-ed teams, and then you can move down to sex-separated teams in the context of contact and competitive skill. And it really contemplates a real, genuine sex distinction in that move down B provision. Mm-hmm. And then, of course, it pivots. It also has the catch-all where it says, but actually in the contact sports, you can't even, you can't move back in the co-ed world. So I think if a state is moving away from a genuine sex distinction as the regulator contemplated and as Congress ultimately contemplated, then maybe they're kind of, if you think of B as a safe harbor in a sense, they're outside the scope of that safe harbor, and now they're running into the problem in A. So I don't think the court needs to get into any of that.
Right, I agree. I'm just trying to know what's coming.
But I think that it's a closer question at least than the equal.
Because your theory is that sex is biological sex in Title IX, or is that not your theory?
No, that is, and it's not our theory, Your Honor. It's just it's the ordinary understanding of what sex meant, both in 72 and 74 when the regulations were themselves implemented. So I think we're just trying to be consistent with that.
Thank you.
Thank you.
Justice Barrett. Justice Jackson?
So I guess I'm trying to puzzle through whether or not there is some independent form of discrimination against transgender women that is distinct from the sex separation that Title IX allows. So I appreciate that your argument is that because the regulations permit sex separation and that hasn't been challenged, that should be the end of this inquiry, basically. And I think you get there because you say you're sort of picking up on this idea that maybe this is just about a definition of who is a male or a woman. Is that right?
I think to some degree, but it's also, Your Honor, it's just because we're indifferent to a person's gender identity in applying the law.
But the law actually operates differently, I think, for cisgender women and transgender women. That is, with respect to their desire to play on a team that matches their gender identity, cisgender women can do it, transgender women cannot. And so we do appreciate a distinction, I think, that is being drawn on the basis of your gender status, gender identity status, trans or cis, right?
So, and I want to make sure I understand
Yes.
if we're operating in Title IX world or equal protection world, because I think it might make a difference to the answer. But
okay, let's start with Title IX.
So Title IX, I think the question of, I look at this statute and see a distinction between boy and girl indifferent to gender identity. And I think that...
Right, but I'm testing that proposition, right? You see that distinction, and I see it too on the separation of teams level at the beginning.
Right, and I think what I'm hearing is that distinction arises from a difference in effect, and I don't see a disparate impact analysis that's sort of hidden away in Title IX.
But why is that a difference in effect? So it's like a second order discrimination, right? The first order is separating male from female.
Right.
The second order is separating transgender women from cisgender women, right?
Respectfully, I would disagree, Your Honor. The reason why is just because I think anytime you have a classification, you could divide it into subclassifications, and I don't think that then becomes, like, the law in the same way applies to brown-haired biological girls and blonde-headed biological girls.
No, I understand, but I don't think you can get...
Based on hair color.
I'm not sure, and maybe this is switching to the equal protection. I don't think you can get out of the implications of making a classification by setting it up as a definition, you know, as a subclass. And so we've already okayed the classification because it's really all about classification. You can't distinguish in that way, right?
Well, I think what the court said on the equal protection side is you look at the facial classification, and I think here it's effectively unconceded that the facial classification is between boy and girl. And I think at that point, if maybe you have a situation where you think that the classification is somehow a proxy for some sort of secret secondary classification, but I don't.
No, but the definition implicates another division. So here's an example. So suppose that we have Title IX exempting, and I think it does this, certain religious institutions from its requirements. And let's say Title IX defined, then went on to define, this is in my hypothetical, religious institutions to include only those institutions that proselytize. I mean, is that a classification problem or a definition problem? I would say it would be a classification problem, and you'd still have to apply all of the heightened scrutiny just because, you know, they're defining religious institutions in a certain way. Similarly here, you have the overarching classification, you know, everybody has to be play on the team that is the same as their sex at birth. But then you have a gender identity definition that is operating within that, meaning a distinction, meaning that for cisgender girls, they can play consistent with their gender identity. For transgender girls, they can't.
So I think that, okay, so as to the part about your ability to pass over from boy to girl,
yes,
you can go from one way but not the other. I want to be clear that BPJ is not challenging that specific classification. I think that's important to start with. But I think, if anything, that's useful evidence as to the lack of a transgender-based discrimination, because if the legislature were just sort of unsettled by the notion of transgender athletes, I think the answer would have been to then bar them from passing over anyone consistent with their gender.
I appreciate that. I guess I was getting at the what I understood the Chief Justice to be trying to discuss, which was this notion that this is really just about the definition of who we accept that you can separate boys and girls, and we are now looking at the definition of a girl, and we're saying only people who were girl assigned at birth qualify.
And there is authority cited in our brief. This court, I don't think, has ever phrased it quite as in the way of this definitional framing that we're talking about right now, but certainly cases like Jana Rock in the Second Circuit do approach it from this sort of definitional framing, and they say that if you effectively concede that there's an initial ability to draw a classification, then that suffices to satisfy the intermediate scrutiny question. But then past that, the definitional question is evaluated through rational basis review, and that's Jana Rock. I recognize this court has never gone as far as that, but I don't think the court needs to go as far as that because, again, I think the way that you would do the analysis is to start by looking to the face of the statute. And if the face of the statute is engaged in a conceded boy-girl sex classification is conceded to be legitimate, then at that point, you kind of know which world you're operating in.
Thank you.
Thank you.
Thank you, counsel. Mr. Lupan?
Mr. Chief Justice, and may it please the court. So there have been a lot of different arguments made this morning, and so I think it might be helpful to just focus on what I think are the easiest way to resolve both of the claims in this case. On the equal protection claim, it's the arguments we discussed this morning about intermediate scrutiny doesn't work on this as-applied basis. So let me focus for the Title IX claim. I think the simplest way to resolve the Title IX claim in this case is as follows. The regs expressly authorize sex-separated teams. The other side isn't challenging those regs. When those regs use the word sex, they obviously use the word sex to mean biological sex in the reproductive biology sense. That's the ordinary meaning of the term in 1972 and 1974. As a result, whether or not they are right that taking testosterone suppression eliminates any physical advantage doesn't matter because the regs define separation based on sex, based on biology, not based on circulating testosterone levels. So the difference that their claim that they've eliminated the difference just doesn't matter under the language of the regs, and that's enough to resolve the case.
Your argument, as I understand it, is that they're not similarly situated.
So that's an additional argument you could make, is to say that even if you just focus on the language of the statute says discriminate on the basis of sex. Discrimination, as this court has repeatedly recognized, including in Bostick, means treating one person worse than someone who is similarly situated. And yes, we don't think a man taking performance-altering drugs is similarly situated to a woman, but you don't even have to reach that question because under the regs, the question is, the regs say you could separate based on sex. Everyone agrees that sex in those regs means biological sex. Therefore, the circulating testosterone levels are just legally irrelevant under the regs.
So why do you say you can separate the sexes? Why are you now taking the position in other cases that if states choose not to separate the sexes in the way you want, that they're violating Title IX?
Well, so again, we think that's a separate question and you should leave it separate, but the argument we're making in those cases is the statute and the regs allow separation based on sex because of the biological differences between men and women. If you purport to separate based on biological sex, but then you allow some biological males to play on the female team, you've undermined the justification for separating in the first place. Because normally you can't separate. If you take, for example, world history class, you can't have world history class for men and women. That's generally prohibited by the statute. The reason you could separate for sex for sports is the biological difference. And if you then undermine that, you've undermined the justification for separation.
So we're now back always to the science. Is there really a difference? And a difference for this kind of person? If it's not clear the way you want it to be in terms of separating the sexes, I'm wondering why it's clear for your attempt to force those states who are choosing not to do this. You're now saying you must.
Again, that question is not presented in this case, and for this case, the factual dispute is irrelevant.
Mr. Mupen, do you think that the spending clause should inform our analysis here?
I don't think this court should invoke the spending clause in this case.
Why not?
For two reasons. One, we think that the statute and the regs clearly do not permit the claim.
I understand that.
And then the second is how the spending clause applies in the context of Title IX is, I think, a little more complicated than my friend suggested. It's not a clear statement requirement. I think if you look at some of these clear notice cases like Jackson and Geyser, I don't think you would say that those statutes had a clear statement.
It's a clear notice requirement.
Right, but how that applies is a little tricky, and I think in the case...
Why? I mean, your argument is that in 1974 and 1960 sex meant biology, and that it's not clearly, there's not clear notice otherwise. Why isn't that the end of it?
Yeah, so I think the end of it is the statute clearly doesn't permit this claim. I'm just saying that I would be cautious about speaking about how the clear notice requirement applies, because it is not a clear statement requirement.
I understand that. You're not answering my question with respect.
So I guess
if it's a clear notice requirement at minimum and a voluntary agreement, and sex at the time of the statute meant, as Bostock said, you know, there's a good argument that it's biology. And why wouldn't West Virginia be within its rights to say we didn't have clear notice otherwise?
The scope of the clear notice requirement is a tricky question. If you look at this court's cases, I suspect...
What's tricky about that?
I suspect Your Honor would think a lot of the cases where this court has found Title IX to apply, you would think there's not clear notice.
All right.
And so I think it's a tricky issue, and I think it's a case that should be briefed, and I don't think it's an issue you need to resolve.
And then on the statute itself, it speaks of discrimination in program or activity, and in Davis we explained that requires kind of a look at the whole of the institution, because the definition of program activity is the whole institution. And so that's less individual focused, it seems to me. Thoughts?
Well, I think that's true for the funding, but I don't think that's true in terms of how the discrimination provision works. If you discriminate or exclude in one part of the school, I don't think you could justify that by saying, well, all the rest of the school, we treat everyone fairly. I think those cases you're talking about, as long as you're receiving funding somewhere, the whole school's activities are covered.
Okay. And so it really boils down to the living accommodations provision, which Congress anticipated there would be sex-separated living accommodations being permissible, the Javits Amendment, and then the regulations that are long-standing and that therefore are entitled to some serious consideration.
Well, no. So, you know, Your Honor asked why we run the similarly situated argument. Take, for example...
Don't bring that back up.
Well, locker rooms and showers aren't covered by any of the things you just identified. Not the living facilities provision, not the Javits Amendment. None of those things covered locker rooms and showers. So unless you use a similarly situated requirement, you would have to say that Title IX bans single-sex locker rooms and showers.
Okay, all right. If that's your view, then let's talk about the similarly situated. I guess I have to. What about the hypothetical I posed earlier that when it comes to high school performance, girls are sure a lot better than boys, and so we're only going to have remedial classes for boys and girls aren't free to attend?
So I don't think those differences are based on inherent biological differences.
Well, let's say I've got really good science. I mean, it's all about the science, right? I got the science. You're finding the hypothetical.
I'm not finding the hypothetical, Your Honor. I think what I would say, Your Honor, is that this court has held in cases like VMI that in general, classification based on sex is impermissible because in general, men and women are similarly situated. Where that's not true is for the sorts of real, enduring, obvious differences that this court talked about in cases like VMI, the differences in reproductive biology. I don't think the sort of pseudoscience you're suggesting has been baked.
Well, it's not pseudo, it's good science.
That's pseudoscience to say boys' brain development happens at a different stage than girls' does.
Well, with all respect, I don't think there's any science anywhere that has suggested that these sort of intellectual differences are traceable to biological differences, and I don't think the statute
with
should be read
respect,
to
I don't think you're a PhD in this stuff, and neither, I know I'm not, but I'm asking to deal with a hypothetical.
And so I guess what I would say about that, Your Honor, is...
I mean, the statute says no discrimination on the basis of sex. Okay. And you're saying, it's okay when they're not similarly situated. And I'm giving you, you're worried about locker rooms, great, I appreciate that, but I'm worried about that math remedial class or the chess club or whatever.
Right, and so look, let me put it this way. The general rule is you have to treat men and women the same. And
I would have thought that's what the statute says.
And I think you have to be very careful about recognizing an exception. And so when you recognize an exception for what's similarly situated, I think you should tether it to the sorts of long recognized differences that would have been recognized at the time the statute was enacted. At the time the statute was enacted, no one would have doubted that it said it didn't require...
Oh, I think at the time the statute was enacted, 1964, there are a lot of people who thought boys are better at certain things than girls at others that we don't believe anymore.
Not based on inherent biological differences.
I think that maybe in 1964 they did.
And if they did, they didn't have any basis for it. Whereas for...
I'm giving you a hypothetical where I have the science to prove it. And you're saying it's still not good enough.
I guess if you're asking me a hypothetical where the science existed in 1972 and everyone agreed with it, then it might be a different inquiry. That really is a hypothetical
Well,
because
Mr.
there
Lucan,
wasn't.
do we have to, I think these are very, very hard questions. I started with the math question before. But do we have to, because of the Javits Amendment, because the other side has conceded that Title IX permits sex-separated sports, can we avoid your whole similarly
Absolutely.
situated argument that you run? Because I don't really like it that much either.
Absolutely. That's why when I stood up here, the first thing I said was the easiest way out of this case on this claim is to say that the regs permit sex separation. They don't dispute
Save
that
locker rooms and all that.
Right. The only reason I went into it is I was nervous that any sort of suggestion that there isn't a similarly situated requirement could lead to results that I don't think the court would actually stand up to, like locker rooms and showers. And so I think I have no problem if the court doesn't take a position on it.
Okay, and I'll say, I said I don't like the argument. At first blush, I don't like it. I'm not trying to prejudice anyone making that argument later, but I think it opens a huge can of worms that maybe we don't need to get into here because the Javits Amendment and the concession.
That's right. As long as you don't cut it off the other way, I think that's perfectly fine.
Thank you, counsel. Justice Thomas? Justice Lee? Justice Sotomayor? Justice Kagan?
Mr. Mupon, you talked about you are litigating this case the opposite way among states that do not prohibit trans women and girls from participating in sports teams. Is that correct?
Yes.
So, and you said, and I appreciate this, that we should not address that question. Are there arguments that do suggest what the answer is on that question that we should be careful about? Or do you think that they're really self-contained boxes?
I think they're generally distinct, and what I could confidently say is the argument that I identified at the outset and with Justice Barrett just now, if you just say that the regs mean sex doesn't mean circulating testosterone, and therefore you're not required to allow boys to play on girls' team regardless of their circulating testosterone level, that argument would not influence the outcome of those other cases one way or the other.
Are there any arguments that would influence the outcome one way or the other?
I don't think so. Maybe if you engage in discussion about what the regs meant with respect to things like equal opportunity, that might be the sort of issue where it might have implications for the other case.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
I just want to be crystal clear about that. If we say sex in Title IX is biological sex, and then we get to the next case, the California case or whatever it is, how would California still prevail if we've said that here?
I think the argument the other side would make would be that the regs don't prohibit them from accommodating transgender individuals. Even though the regs permit separation based on sex, they also don't forbid accommodation of transgender individuals. The argument they would make. And they would say it doesn't matter that you're allowing some boys who have a biological advantage to play on the girls.
What's the argument you're currently making in opposition to that?
That the justification for separating on the basis of sex is the biological difference, and so you're undermining the justification for the separation.
Right, and so we start with the separation. I think what you're saying is once you separate boys and girls teams, which everyone does, and it may be even required in my view, to have equal girls teams, then California really doesn't have an argument if we say that sex in Title IX means biological sex, which may be okay. I just want to make sure I know what we're doing.
Look, Your Honor, obviously we don't think they can argue that, but I'm confident that California would stand up here and say that even if you ruled the way I just urged, they should be able to argue the opposite by saying essentially that they're allowed to accommodate on the basis of gender identity, even though the regs mean sex and sex means biological sex. That's the argument they would make. Whether that argument's right or wrong is for another case, but I don't think if you adopt the argument I'm making here today, their hands are going to be tied.
Okay, and then on this premise that has been conceded, I just want to make sure I understand your view. My understanding is that it's sex-separated sports teams, so long as they're equal opportunity for girls and boys, are perfectly constitutionally permissible. Is that not your understanding?
Yes. Per the arguments in both cases.
I mean, it's conceded, but it's conceded because it's obvious.
Right, because there are obvious biological differences between men and women, and that's why.
Well, the why people may debate, but it's obvious, it's conceded, and so too Title IX, because of the Javits Amendment, at least, even if not Title IX originally.
Well, I would say even without the Javits Amendment, because importantly, the Javits Amendment is only intercollegiate. So.
And it's been interpreted in the regs, so to go to high school and no one's ever challenged that part. That's the part, okay.
Right.
But that also, sex-separated sports teams are perfectly permissible under Title IX, at least with the Javits Amendment and probably without, correct?
That's right.
And that's conceded, but that's, it's conceded again because everyone accepts that and has accepted that for a long time, so long as the opportunities for boys and girls, men and women are equal.
That's right, and I think what the other side in this case is trying to do is say that that's fine, but they're being excluded. And the problem with that is they're not being excluded from participating on the boys' team. They're choosing not to participate on the boys' team. Now, for understandable reasons, given their gender identity, but the state is not excluding them from the boys' team. And Justice Sotomayor, this explains the confusion in the Fourth Circuit's opinion, because I agree with you. It is very strange that the Fourth Circuit
we got to go back. Sorry. You can, finish that off. Sorry.
The reason why the Fourth Circuit found that there was a viable Title IX claim, even though they said that there was a factual dispute, is because they bought into this notion that because the transgender boy doesn't want to play on the girls' team, doesn't want to play on the boys' team and can't play on the girls' team, they're excluded. That's true even if they have a physical advantage. And so the court said, we don't care about the physical advantage, it's still a Title IX violation. And that's clearly wrong. That's a misinterpretation of the statute. And the error in it is that they're not being excluded from the boys' team, they're choosing not to participate on the boys' team.
Sorry, one more. Bostock does not control here because, fill in the blank.
Because the law doesn't classify on the basis of transgender status, it classifies on the basis of sex, biological sex. Just like in Scrimeti, the law there classified on the basis of age and medical treatment. Here, the law classifies on the basis of biological sex. The person's gender identity is wholly irrelevant to how the law applies.
Thank you.
Justice Barrett? Justice Jackson?
But they are being prevented from playing on the team that matches their gender identity, correct?
That's the effect. So let me use your example from earlier. You said there's a cisgender woman, she could play on the team she wants.
Right.
There's a boy who identifies as a girl, he can't play on the team he wants. Take that same boy and switch his gender identity, but say he still wanted to play on the girls' team. Say he was a very unathletic boy. He likewise couldn't play on the team. So it's not the gender identity that's keeping him off the girls' team, it's his biological sex. His gender identity is wholly irrelevant to it. Now, I agree with you, there's a very significant disparate impact on transgender individuals by this law because they're the boys who are most likely to want to play.
Have we said that Title IX never covers that kind of disparate impact in terms of its discriminatory effect?
Well, it certainly doesn't cover disparate. First of all, I don't think Title IX covers disparate impact, period, because it uses.
But in terms of its discriminatory effect, I'm just trying to understand it. Is there something to this notion that differential treatment in effect in this way could be something that Title IX cares about?
I don't think Title IX covers disparate impact even on the basis of sex, and it certainly doesn't cover disparate impact on the basis of gender identity.
Okay.
Thank you, counsel. Mr. Block?
Mr. Chief Justice, and may it please the court, BPJ signed up for school sports because she was an 11-year-old girl starting a new middle school who wanted to meet people, make new friends, and be part of a team. West Virginia argues that to protect these opportunities for cisgender girls, it has to deny them to BPJ. But Title IX and the Equal Protection Clause protect everyone, and if the evidence shows there are no relevant physiological differences between BPJ and other girls, then there's no basis to exclude her. In thinking through the Title IX claim in particular, it's important to distinguish between how Title IX operates as a general matter and how it operates outside the context of athletics. And I'm glad that we're doing that this morning. Instead of focusing on athletics, West Virginia argues more generally that this court's reasoning in Bostock does not apply to Title IX. To distinguish Title VII from Title IX, West Virginia argues that Title IX protects groups instead of individuals and applies only when sex is the sole cause of adverse treatment. That approach takes a wrecking ball to the text of Title IX and the structure of this court's anti-discrimination precedents. It would dilute Title IX's protections for everyone, not just transgender students and not just in the context of sports. West Virginia's law treats BPJ differently from other girls on the basis of sex, and it treats her worse in a way that harms her. Outside the context of athletics, that's all BPJ would need to establish a Title IX violation. But the Javits Amendment provides extra breathing room for reasonable regulations that take into account sex-based differences in athletics to provide equal athletic opportunity for everyone. West Virginia's exclusion of BPJ does not fall within that framework. Unlike the exclusion of a cisgender boy, excluding BPJ doesn't advance any interest in ensuring overall fairness and safety. And unlike the case of a cisgender boy, excluding BPJ from the girls' teams excludes her from all athletic opportunity while stigmatizing and separating her from her peers. I welcome the court's questions.
Doesn't your claim ultimately depend on the existence of sex-segregated sports?
Yeah, no, I don't think so, Your Honor. I think this is similar to Morales-Santana, where the claim was an equal protection claim.
Well, I mean, let's say there were no Title IX requirement for sex-segregated sports.
Yeah, well, if there were no Title IX requirement, and well, I don't think Title IX requires sex-segregated sports.
Well, permits.
If there were no Title IX and all the sports were co-ed, then she wouldn't be subjected to disparate treatment on the basis of sex. So I think the claim is the discrimination, and it's perfectly possible to.
So doesn't that suggest that your subcategory of the sex of the relevant class of female athletes? Isn't that your point?
Yes, well, for the equal protection claim.
Well, but you're not. My point is that you're challenging a category that does not exist in the statute, but is dependent upon the existence of a category in the statute that you're not challenging.
Well, I wouldn't put it that way. I would put it the way as there's a classification that we think is valid as applied to most people, but is invalid as applied to a discrete subset of those people. But I don't think the success of that equal protection claim hinges as an a priori matter on the existence of girls' teams. There are lots of ways to remedy an equal protection violation.
But I think, given the way you phrased it, the question becomes a little different, because what it seems to me you have to establish is the basis for requiring an exception to the classification. You're not challenging the idea of having boys and girls separate sports. You're saying that you cannot exclude transgender girls from the definition of girls. And that's an entirely different question than the equal protection question.
I don't think we're arguing for an exception. I think we're bringing exactly the same argument in Caban. In Caban, the plaintiff wasn't saying, this is valid for everyone, but I want an exception from it. In Caban, the plaintiff was saying, this is valid for other fathers, but it's not valid as applies to me. So I just think it's an as-applied equal protection claim. I understand the court might decide those claims don't exist, but I don't think it's a claim asking for an exception. It's a claim saying it's as applied to them, it's okay, as applied to me, it's not.
Counsel, how do you get to a Title IX violation? I know exactly how you get to an equal protection violation, okay? When if you accept that the regulation does, by its own terms, permit sex-based separate sports, does permit schools to do this. What in Title IX explicitly or even logically says that you have to give transgender
Thank you. I appreciate
girls the same opportunity? Because the regulation said, it's not just the statute, it's the regulation said, you can create separate sex teams.
No, thank you. I take the point. I think there's always been a tension between the underlying text of Title IX, which protects individuals, not groups, and the regulations, which are authorized by the Javits Amendment and have special leeway to make some group-based measurements. But if you look at the rationale for the regulations, Hugh, when it issued the regulations, said that we think that our group-based method, which otherwise would have been completely impermissible for Title IX, adequately protects the rights of individuals. Because if boys and girls as groups are being given equal sets of overall opportunity, then every individual in the group also has a set of equal opportunity to choose from.
Yeah, I think that's the problem. And, you know, you're absolutely right to worry about the wrecking ball, but I think we've kind of taken a wrecking ball to that. There's no solely in the statute, all right? We're talking about individuals, but Javits changed Title IX, and it said, you know, sports are different, and we've got these regulations that have been out there for 50 plus years, and, you know, normally Skidmore kind of comes in there. Forget about the spending clause, I guess, but maybe I'll ask you about that too. Well, why doesn't that make this case very different than Title VII?
Yeah, so I completely agree. The Javits Amendment is what makes this different from Title VII, and I'm very happy with however this decision comes out, to have a decision that's focused specifically on the unique context of athletics as opposed to these broad arguments about Bostock applying to Title IX as a general matter. But I guess what I'd say is the regulations still require equal athletic opportunity. It's not a complete exception for sex-separated teams.
Yeah, but Javits says it can be reasonable.
Yes.
And do you dispute that the Hugh regulation that's been on the books for 50 plus years is reasonable?
I think it is absolutely reasonable as applied to cisgender students. I think that as applied to transgender students, instead of providing them equal overall opportunity, it's a complete exclusion from the program. And so that's our argument, that it's reasonable as applied in the context of cisgender people, but interpreting the regulations to authorize this sort of categorical exclusion that doesn't give BPJ an equal set of opportunities to choose from would be an unreasonable way to implement Title IX.
Okay, gotcha.
It's unreasonable as to all transgender students?
No, I think it's a combination. I think so. A reasonableness test, I think that requires some sort of ends means fit, and I think that exists when it comes to cisgender students. I think what makes BPJ's case differently from a cisgender student is two things. First, she doesn't have any of the physiological distinctions that justify the sex separation in the first place. And second of all, the harm to her is of a material different kind. It's one thing to say, we're not gonna let boys play volleyball because they have all these other sports to choose from, or we're not gonna let girls play football because they have all these other sports to choose from. It's another thing to say, you don't get any sports.
But in that argument, does it matter whether BPJ has a competitive advantage or not?
Yes, we think it does, and I appreciate the opportunity to clarify that we don't have any objection to vacating the grant of summary judgment in our favor. We did our best to defend the judgment below, but our argument before the Fourth Circuit for summary judgment was that there wasn't a genuine disputed fact about whether she had an advantage. The Fourth Circuit, sua sponte, granted summary judgment to us based on the theory that that fact wasn't material. That's never been our argument in this case.
So your argument depends on depends on her not having a competitive advantage because she's not been through male puberty.
And not just not been through male puberty, but also gone through a female hormonal puberty,
right,
with all the physiological changes accompanying it.
But that the argument goes away if those facts go away.
Yes, absolutely. Which is at the beginning of the argument, Justice Kagan, you talked about this could be resolved based on a legal principle or based on the facts. And I really do want to make a pitch for the resolving it based on the facts because, look, if they're right about the facts, then we should lose. And the irony is that in order to win summary judgment in this posture, when there's a disputed question of fact below, is they can only win in this posture if we're right about the facts and there aren't any advantages. And I don't think there's any need at this juncture for this court to issue that broad a holding when, according to them, once the evidence comes in below, we're not going to get past summary judgment. I mean,
you're not suggesting that we decide the factual question.
No. I'm suggesting that the case be allowed to be decided on remand on the factual question, which I think, like, this is an important issue. It may affect the whole country, and the court wants to get it right. And I don't think the best way to get it right is to rely on, cherry-picked studies or assertions in amicus briefs. I think the way to get it right is to let all the facts they're trying to put in the record actually be put in the record. And then we'll have the facts in front of us, and maybe they'll make the issue go away. But I think that's unnecessary to intervene at this instance with a sweeping legal conclusion to something that might actually be a narrow factual dispute.
Counsel, can you explain whether or why your theory would allow a cisgender boy who just couldn't make the boys' team? I mean, he doesn't have an equal opportunity, he can't play, there's no team he can play on, and let's say that his athletic ability can be shown that he has no competitive advantage and he wants to be on the girls' team. Why can't he on your theory?
I appreciate the question. I just want to be clear about what we think the justification for the separate teams is. We don't think the boys' team is for better athletes and you have a backup team for athletes that aren't as good. I think the purpose of the teams is to control for the variable of sex-based advantages so that talented women athletes have all the same opportunities as talented male athletes. But also, untalented male athletes should be compared to untalented women athletes. So they're not being separated based on how good you are, right? The whole point is to allow female athletes to have all the same opportunities as men by controlling for the sex-based differential that comes through puberty. And so that's why I don't think that the claim is the same there. I think that's what's happened here is by virtue of her medical care, BPJ has already effectively controlled for those sex-based advantages. And so she is completely in the position that she would have been if her birth assigned sex had been female. As opposed to a cisgender boy who's just not very good at sports, and if his birth assigned sex were female, maybe he'd be even worse, I don't know. But again, the purpose is to control for the variable of sex to provide equality, not to have a good team and a team for people that can't cut it. Now, I'm happy to address—
Can I ask a question on the law?
Yes.
On Title IX? I mean, I hate that a kid who wants to play sports might not be able to play sports. Hate that. But it's kind of a zero-sum game for a lot of teams. And someone who tries out and makes it, who is a transgender girl, will bump from the starting lineup, from playing time, from the team, from the all-league, and those things matter to people big time, will bump someone else. And so one way to resolve that, as you say, is the facts, try to figure out, is there really a competitive advantage? I think we're going to get a lot of scientific uncertainty about that, a lot of debate about that, a lot of different district courts. The other way on the law, one way on the law is, okay, well, sex in Title IX and in Javits meant biological sex, and it's up to Congress to adjust that going forward if they want, given, as you say, and your co-counsel said earlier, people are learning more about this, and maybe there really is no advantage. Well, if that's true, and some states are operating under that basis, that's the way to go. But for now, at least the law says biological sex, and I think we have to recognize on both sides the zero sum. It's not like, oh, just to add another person to the team. That's not how sports works. It's someone else is going to get disadvantaged. So I just want you to address that.
I'm happy to, and I guess I have three answers. I mean, the first is I completely understand that many parts of sports are zero-sum, but this law isn't limited to zero-sum opportunities. So BPJ played on the cross-country team where there were no cuts. She came in near the back. It wasn't
but I'm sorry to interrupt, but you wouldn't have a different rule if she was finishing in the top 5.
No, but it wasn't a zero-sum.
Or if they had cuts.
But what I'm saying is in
this particular case, but usually with teams, I don't mean to, just don't want to get out of that. Usually with teams, they're cuts.
Yes.
Those mean a lot to people. There's starting lineups. Those mean a lot to people. There's who gets a college recruit. That means a lot to people.
Yes. I just want to say that there still are some areas where there are win-win solutions. I think even being able to be on practices with a team consistent with your gender identity instead of your sex assigned at birth can be enormously important. So I think some scenarios are zero-sum, but not everything having to do with sports is. And I do think that one of the vices of this law is that it sweeps so broadly that even win-win solutions are taken off the table. In terms of aspects where it's zero-sum, no one likes to lose. No one likes to not make the team. And people often don't make the team. The cisgender girls don't make the team when competing against other cisgender girls all the time. And the question, I think, is whether it's an unfair advantage to not make the team because a transgender girl participated. And if there is no sex-based biological distinction there, then I think it's an unfortunate situation, but I think it's the unfortunate situation that comes with having a zero-sum game, not inherent unfairness. Then the third thing is, I think however the court resolves this case, I really urge the court not to do it based on a definition of sex argument. We are not disputing in this case that West Virginia can have its definition of sex. Our argument is it's using this definition to inflict discrimination and deny equal athletic opportunity, but we are not saying their definition of sex is wrong. However, I don't think it follows that Title IX created some national definition of sex that preempted states' ability to say, actually, we are most concerned about discrimination that happens through gender roles.
Can I ask you something? That's a very important point here, I think, for what happens in the future, what you just said. Do you think sex in Title IX can reasonably be interpreted to allow different states to take different understandings of that in their sports leagues?
I do, because I don't...
Why is that? That's real important, I think, going forward.
Right. Because I don't think the purpose of Title IX is to have an accurate definition of sex. I think the purpose is to make sure that sex isn't being used to discriminate by denying opportunities. Just as I don't think we need to define race in order to enforce Title VI. So I think I wouldn't look to whether or not it's accurate to classify, BPJ as male or female. I think the question is she being denied an opportunity because of that classification? But obviously sex can mean more than just
So if we didn't want to prevent a different state from making a different choice from West Virginia, what should we not say, or what should we say to prevent that from happening?
Well, I wrote down the answer to that when you asked Mr. Mupin. I have two things. I wrote, don't give definition of sex, and I also said I wouldn't decide this by assuming that Title IX provides a right to single-sex teams. In the regulations, single-sex teams are optional, they're not mandatory, and in addition to that, we're talking about the regulations, but on the ground, the way this plays out in practice is you have a 1979 policy statement, a sub-regulatory document that has a complicated test for determining when a sex-separated team is or is not required. And so I think that both because I think saying there's a right to a sex-separated team would predetermine some of the questions in that other case. That's one reason why I don't think you should do that. But second, I think the more the court gets into questions that are handled in these complex regulatory documents, I think the more I'd be worried about this court accidentally saying something about how Title IX works that doesn't actually map on to how it is actually playing out on the ground.
Title IX prohibits discrimination on the basis of sex. It's a statutory term. It must mean something. You're arguing that here there's discrimination on the basis of sex. And how can we decide that question without knowing what sex means in Title IX? I mean, it could mean biological sex, it could mean gender identity, it could mean whatever a state wants to define it to mean, but it has to mean something. How can we decide that without knowing what the statutory term means?
Well, I think there are a whole range of sex-based characteristics that can give rise to discrimination. I think if someone said, I'm going to discriminate against anyone who acts in a feminine manner, like anyone with limp wrists, I don't care who they are, but I'm going to discriminate against them. I think that would be sex discrimination. It would be sort of gender presentation. But I wouldn't say that's not covered by Title IX. And so I'm not saying that biological differences aren't part of sex, but I'm saying that sex also has broader connotations, and there's no reason to keep that out of the statute. And I'm certainly not saying that sex means gender identity. I just want to be very clear about that. I don't think that, just as, I would say this, our argument is that there's a group of people who are assigned male at birth for whom being placed on the boys' team is harmful, right? We happen to have a word for those people. It is transgender girls. But I don't think that means that we're elevating gender identity to be the new definition of sex. Just as in Phillips versus Martin Marietta, there's a subset of women, who are harmed by the policy. Not all women, but there's a subset of women who had young children. And there's a name for them, it's mothers, but that doesn't mean that we're replacing the word sex with mothers. I think
How do you respond to or deal with the other side's characterization of that harm as just the disparate impact of this regulation? That really, it's not discrimination, I think they're saying, but it is just the downstream effect of the application of the classification that the Javits Amendment allows, and that's just the way it goes.
Yeah, so I guess I would say this. I think this court has dealt with the issue of things like constructive denials and constructive discharges in a variety of contexts. And under Title IX, an outright denial isn't required. Davis says a constructive denial it also counts. And whenever there's a question of constructive denials, the court applies a standard that's reasonable person in the plaintiff's position under all the circumstances. And they use that for constructive denials. You've used that for retaliation claims. And if you look at Burlington versus White, I think it's very on point here, because one of the points that Burlington versus White said is that there's some actions that aren't going to be harmful to most people, but they might be harmful to some people. So Burlington versus White used a mother with young children might find a change in her work schedule to be incredibly harmful, right? That doesn't mean that, we're arguing that, this is a disparate impact classification on people who have young children. It's a sex classification. The sex classification is just harming some people and not harming other people. So that's how we would view it. I think this is a facial sex classification any way you cut it. And
I'm sorry, you don't think we should have an operating definition of sex in Title IX? Now, I understand the idea that, the question then becomes not whether or not there's discrimination on the basis of sex, but whether there's discrimination on the basis of whatever characteristic you think should be included in the definition of sex. Now, when it's used as a statutory term, I'm not sure you have that kind of flexibility. The question then would be instead, what does Congress think the word means?
Well, Your Honor, I guess I'd say I think Congress prohibited discrimination based on sex.
I'm sorry, go ahead.
Yeah, and so I don't think that, just as I don't think Congress adopted a definition of race, in Title VI in order to prohibit discrimination on the basis of race. I think I'm not trying to police the accuracy of the terminology that's being used. All I'm saying is that what's being prohibited is using this classification to discriminate, not.
So but without really knowing what this distinction is.
Well, I don't think the examples I've given about sex-based characteristics fall outside the common understanding of things that are related to sex.
Well, related to sex, I guess what you're saying is that we do have to accept for your position that we're not dealing when Congress says sex, we're not dealing with biological sex. But we're dealing with other characteristics that people might associate with sex?
No. I think for this case, you can accept for the sake of this case that we're talking about what they've termed to be biological sex. I think that resolves this case. I was just talking about in addressing other potential cases.
So we don't have to say anything about the matter. You're willing for us to proceed on that assumption.
Exactly. Just like in Bostock, I think you can proceed for argument's sake. Without taking a definitive position here, because it might have downstream consequences in other cases that even the United States doesn't want the court to prejudge here. Now, I would like to say one quick thing on Justice Barrett's reference to separate classrooms. I mean, it is true, and the ACLU's litigated cases about theories that there's different brain sexes for women versus boys, and that's why you need separate classrooms. I think the instinct was completely correct that you can have a lot of scientific justifications for discrimination. That doesn't mean that the discrimination is allowed or immune from scrutiny. And in fact, some of the studies that are cited in the amicus brief say boys are naturally more aggressive, right, and favor competition more because that's in their DNA. So I do think even in these studies, the idea that you're completely, just basing it on pure biology and not on other generalizations doesn't quite hold up. I'd also, to the extent that we want to go back to Caban, I do want to just make a couple quick things clear. Caban was not a facial challenge. It wasn't. And neither was, some of the First Amendment cases they were talking about weren't equal protection First Amendment cases. They were commercial speech cases. Michael M. also wasn't a facial challenge. He wasn't saying I should have an exception because a prepubertal girl was involved. He was saying the statute is overbroad because in theory it could apply to a prepubertal girl. So I do think that some of the characterization of the cases doesn't hold up to our reading of them.
So how does a Caban type as applied intermediate scrutiny analysis work in your view? It is an underdeveloped area of the law. Is it enough for one person to show that she bucks the trend or not?
Yeah, I don't think so. I think I agree with my co-counsel that I think we're talking about a discrete, definable group that will reliably not serve the government's interest. And I don't think Nguyen is a counterpoint to that, because the whole point in Nguyen was that men who were not similarly situated had an opportunity to demonstrate that. There are 3 very easy methods of transmitting citizenship. And Nguyen emphasized that in order to do it, those were minimal burdens. And that is the key fact in Nguyen that distinguishes it from this case. This is a categorical ban, and Nguyen and Caban and all the court's cases distinguish between categorical bans and more narrow procedural requirements that do treat men and women differently, but still provide the opportunity for demonstrating that you're not similarly situated.
I think a hard question that Ms. Hartnett got, maybe the hardest question on these lines, was if we recognize these sorts of as-applied challenges, doesn't that effectively turn intermediate scrutiny into strict scrutiny? Right. What would your answer be to that? Would it be any different, or
no,
do you want to elaborate?
I think the answer is it absolutely wouldn't. You still are only looking for a substantial relationship, which means that you can have these sorts of requirements where there are a lot of, under Caban and under Lair, there's still a lot of fathers that are out of luck, that they actually probably do have a good relationship with their kid, but they didn't fill out the right paperwork, they didn't do this, they didn't do that, and heightened scrutiny doesn't require that they be excused from those procedural burdens. So I do think that heightened scrutiny allows you to have procedural requirements that people have to go through, and those can be enforced. Strict scrutiny does not allow that. But that's different from saying that if the complete rationale for a classification just doesn't apply to you, that there's no equal protection claim you can bring. And some of it's complicated to talk about the difference between facial and as applied post-CASA, because I think a lot of the things that we called facial challenges now would be viewed as overbreadth challenges, right? Where someone is trying to say the law is so overbroad in general, it has to all be struck down. And we have that for First Amendment. I don't think we have that anymore for most equal protection claims. And so I think taking this facial as applied framework from before CASA, where we allowed these facial attacks on statutes, and then just transporting it into as applied cases post CASA doesn't necessarily work. I think some of the terminology might need to be rethought. And so, again, that's another reason why there's not a lot of precedent in this area, as several of you all have acknowledged. And that's another reason why I don't think this should be the case that makes that precedent when it's unnecessary to do so.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
Would you address a little bit the quantum of certainty or uncertainty that would have to exist in the science? Your co-counsel, or the counsel in the other case, said that if it's 50% percent, the state loses. But I'm always hesitant about these percentage cases because it's never it's never quantitative, it's qualitative. So what do you think the qualitative standard is?
Well, I mean, to be clear, I don't actually think there's uncertainty in the case of someone who's had puberty blockers and then gender-affirming hormones. Our position is there's zero uncertainty. It's actually clearly in our favor. So but in general, I think it's hard to give, a quantitative answer to that. I think part of heightened scrutiny involves taking all of these factors into account. This court, has said on several occasions that heightened scrutiny can accommodate deference. And I honestly think it's a case-by-case decision that also looks at how harmful the classification is, how burdensome it is. I don't think you just look at the accuracy of the classification and add a number value for how certain we are that it's accurate. I think many other factors come into play.
Justice Kagan? No. Justice Gorsuch? Justice Jackson? Thank you, counsel. Rebuttal, Mr. Williams?
I think you've now heard respondent abandon the Fourth Circuit's logic on Title IX, and I think in many ways that makes this court's task that much easier. Congress authorized regulations allowing sex-separated athletics. West Virginia's definition of sex tracks the ordinary meaning in 1972 and 1974 and the regulatory framework that Congress endorsed. I think, Mr. Chief Justice, your question really highlighted how BPJ's approach unmoors the statute and the regulation under Title IX on the basis of sex. BPJ's test in turn begins to look more towards other characteristics that aren't on the basis of biological sex, and I think that's not consistent with what we see there. I also think the answer to Justice Barrett's question reflected how under BPJ's theory this really isn't about competitive advantage, that really what this does turn on is gender identity, because BPJ continues to maintain that a cisgender boy who continues to not have those same biological advantages would nevertheless still be kept off of the girls' sports team. So if you endorse that philosophy, that would require the court to hold that long-standing Title IX athletic regulations are unlawful. It would eliminate sex-separated athletics entirely, and I think it would defeat Title IX's core purpose of ensuring equal athletic opportunity for both sexes. On the equal protection side of the House, the question is whether the classification is substantially related to an important governmental interest. And I think that BPJ ultimately wants to rewrite the classification to be something that it is not. Biological sex substantially relates to athletic performance. That's exactly why, in fact, Title IX regulations authorize sex-separated teams in the first place. Respondent's test effectively ratchets up the intermediate scrutiny standard into a perfect fit, best disposition case that this court has repeatedly said is not the standard under intermediate scrutiny cases. That is the standard for strict scrutiny cases. You have heard it several times today. Justice Sotomayor, you asked about deference. I think this court has also repeatedly recognized that in areas of evolving science and medicine, especially involving children, legislatures have the primary responsibility for weighing competing evidence and making the policy judgments. I think the court just recently said that in Scrimeti, but I certainly don't think that case stands alone in recognizing that, especially when you have competing balances of harms, Justice Kavanaugh, when you're weighing these sorts of zero-sum games, that's a choice, that's a policy judgment that ultimately rests in the hands of the legislature. In the end, this court has, quote, recognized physical differences between men and women. They are enduring, and inherent differences between men and women are cause for celebration. That is all that West Virginia's law does here. It should be upheld. Thank you.
Thank you, counsel. The case is submitted.
Should female athletes have their own protected space to compete, to excel, and to pursue their dreams? And the answer is obvious to anyone and everyone who is honest. It is rooted in basic biology, observable reality, and common sense. Men and women are different. Men and women are different in bone density, lung capacity, muscle mass, and countless other ways that impact athletic performance. These differences do not disappear because of confusion. They don't disappear because of hurt feelings or because of someone's preferred political ideology. These differences do not disappear based on who holds public office in your state, your county, or your district. They are constant and they are universal. And the question today isn't merely a legal or athletic question. It reflects something far deeper. We must get it right. It's a moral and spiritual question regarding truth. And we know that God created male and female in His divine image.
It's a promise that made to her when she came to me at 4 years old with some questions about her own gender journey. And I intend to keep the promise that I made to my child, regardless of where that journey
are women from conception. And that is a good thing. It is good to be a man. It is good to be a woman. And we should celebrate those distinctions proudly and not erase them.
Our opponents claim to champion fairness, but their actions reveal a full version
and equal protections when it comes to education and athletics. Entire generations of women fought for and championed these rights.
We're talking about a tiny handful of transgender athletes across this entire nation. Yet, they have manufactured a moral panic to justify stripping these kids of their dignity, their community, and their chance,
everywhere else,
children,
including medicine, life-saving treatment, and irreversible interventions based on confusion rather than facts.
If it were, these same legislators wouldn't simultaneously be banning the very medical care that will allow transgender and cisgender girls to compete on working terms. The contradiction exposes the truth. This is about erasing transgender children from public life entirely, and we say no. It's not going to happen. It's not going to happen in our lives. And we're going to do everything that we can to ensure that our kids have the protection and freedom that all children have.
And secure space on and off the field of competition.
Now, what they're really saying over there is that some children matter less than others. That some kids deserve protection, while others deserve persecution.
That protect them from exploitation and experimentation.
I'm a practicing
and love for the truth
and as a practicing Christian, I know that God made us all in God's image.
For a just and free society.
It is my calling and vocation and duty as a Christian to fight for each and every creation that was made in the divine
and fairness in America and in athletics. And to say that reality matters, women matter, and the truth matters. We are standing on the right side of history. We are standing on the right side of truth. We are standing on the right side of justice. And we are standing on the right side of love. Thank you, and God bless you.
And the moral obligation to declare that in America, no child's humanity is negotiable.
All right, so exciting. The argument's now wrapped up, so we're waiting for the attorneys and advisors walking out here shortly. So when they do, we're going to want to raise our voices and show them how much we appreciate everything they've done in there. But while we're waiting for that, and then we'll have some speakers after that as well. So we're going to make their way over to the press conference. But while we're waiting for them, let's continue to make our voices heard. Save women's sports. 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 Save women's sports.
They don't ensure
Save women's
safety.
sports.
They endorse
Save women's
bullying.
sports.
Because
Save
saving
women's
women's
sports.
sports would be
Save
saving
women's
and
sports.
protecting all
Save
women
women's
and
sports.
girls.
Save
And when we
women's
talk
sports.
about saving and protecting all women and
Save
girls,
women's sports.
we mean all.
Save women's
Not with
sports.
an exception.
Save women's
Not with
sports.
an asterisk.
Save
We
women's
mean
sports.
all
Save
women
women's
and
sports.
girls. And that
Save women's
includes
sports.
transgender
Save women's
women
sports.
and girls.
Save
And
women's
it
sports.
is our
Save
say,
women's sports.
shalom.
Save
And
women's
any
sports.
other word that means so be it in your tongue.
Save women's sports. Save women's sports.
Today we
Save
ask
women's
this court to honor its
Save
highest
women's
truth,
sports.
to protect
Save
the
women's
constitutional
sports.
rights of
Save
all
women's
Americans,
sports.
especially
Save women's
those whose
sports.
rights are most under threat. To affirm that
They should be coming out here soon. When they do, we're going to give them a
to
big round of
declare
applause.
that
all right?
every single child deserves to grow up in a nation that celebrates who they are, just as the divine does. Not one that criminalizes their existence. As I said, the promise I made to my daughter to support her regardless of her gender identity, whether soon one day I may refer to her by different pronouns or different terminology. It is a vow and a commitment that I stand behind firmly. And it is a promise that America must make to all of its children. We're here to ensure that this court keeps its promise. Because no matter who we are, no matter how we identify, no matter who we love, no matter where we come from, when the Constitution says it is a document that is interpreted by this institution to support each and every one of us, we demand and declare, and we say, once again together, that equality under the law means equality for everyone. Equality under the law means equality under the law means equality under the law means equality for everyone.
All right, everybody, hold up your signs. All right, let them know you're out here. The attorneys, the advocates, the clients are getting ready to come out. We're going to let them know how much we appreciate all the work that went in to the argument. They're going to walk out here when they walk out. Let's show them our appreciation.
Warriors from the inside coming out after we finish with our last week speaker.
All right, let's go.
Thank y'all for hanging in there. So we have Jen Lynn Walker, who is the co-chief of campaign at the Center for Popular Democracy.
Thank you so much. Good afternoon. I know we all want to hear what just happened. My name is Jennifer Lynn Walker, and I serve as the co-chief of the Fight Back Team of Popular Democracy. We're a network of 48 of the most badass.
Sure.
All right, everyone, we're going to be hearing from a West Virginia Attorney General, J.B. McCuskey, Idaho Attorney General Raul Labrador, and then female athlete Madison Kenyon, and Alliance Defending Freedom Attorney John Birch.
Hi, everybody. My name is J.B. McCuskey. I'm the Attorney General of the state of West Virginia, and I'd like to start by thanking the team of lawyers that we've assembled here in West Virginia. Anybody who listened to this argument heard Michael Williams deliver a masterclass in constitutional litigation. He was truly remarkable in his arguments. What we take out of this case and what I saw in the courtroom today was that the ACLU has conceded both the legal and constitutional questions that were presented. And what they're seeking to do is to whittle down the idea of an intermediate scrutiny case to where a subclassification of people can be so small that no longer could any state have any kind of rational law based on any sex-based classification. I feel incredibly great about our arguments, and I'm really, really excited to answer your all's questions. Raul.
I'm Attorney General Raul Labrador from the great state of Idaho. I want to thank our team for the work that they did today. Alan did a fantastic job. Alan Hertz, our Solicitor General. I think both teams did a fantastic job, and they were able to present what I think should be common sense. There was a lot of rhetoric today in the courtroom, and there were a lot of legal issues that maybe a lot of people do not understand, but the simple reality of this case is that we're talking about simple biology. There are men and women, and Title IX and equal protection should allow boys to participate in boys sports and girls to participate in girls sports, and should allow girls to have the safety and security of knowing that they're going to be safe in their spaces, they're going to be safe in their sports, and that they're going to be protected by the law and by the Constitution. So thank you all for being here, and we're so grateful for the opportunity we had to talk about these issues today.
Hello, my name is Madison Kenyon, and I'm here with Mary Kate Marshall and Lainey Armistead. We are here because we value fairness and safety in women's sports. We know what is at stake when states can't provide these protections to athletes, to their female athletes. I was a track and cross country athlete at Idaho State University. 5 times I lost to a male athlete who identifies as a woman. Being a competitive athlete is about sacrifice. The day after day of getting up early, the events you skip because you can't stay up too late, the limited summer vacations you miss. The limited summer vacations you have because you have to ensure you can train. The family and school events you miss because you have to either compete or train. As collegiate athletes, all 3 of us can attest that we are not making sacrifices for our participation trophy. Those sacrifices get us ever closer to beating the odds and taking home a victory. Having athletic opportunities are a game changer for women. Before Title IX, athletic scholarships for women were almost unheard of. Today, athletics not only opens doors for women in sports, it gives them a chance to win. It gives us a chance to win scholarships, to help support our educations, and pave a future career. Competitive female sports are the gateway to numerous opportunities for women that we didn't have before Title IX. I can attest for this in my life, and so can the women standing next to me. While women can beat the odds, we can't beat biology. As an athlete and a nursing major, it is absurd to suggest that it is fair to put men in women's sports. It's like racing a cheetah against an ocelot. Sure, they're both fast cats with spots, but we all know who is going to win. Today, Idaho and West Virginia stood before the U.S. Supreme Court and said that they wanted to protect fairness for women's sports. I am so proud to be from Idaho, and I am so proud of West Virginia for standing up for the rights of women and girls, specifically the Attorney General Labrador and Attorney General McCuskey. Idaho's law protecting women's sports reflects reality. Men and women are different, whether some want to admit it or not. You can't change those differences by suppressing testosterone. Women don't join sports for a participation trophy. We want to win. We work to win, and we deserve a fair shot at winning that trophy and taking home a victory. I'll happily compete against challenging odds, but nobody should lose the race before it has started. We are hopeful that the court will see Idaho and West Virginia's laws for what they are, a respecter of biology, fairness, and women. Thank you.
Now we'll hear from Alliance Defending Freedom Attorney John Birch, and then we'll be open for questions after.
Hi everyone, I'm John Bursch. I'm with Alliance Defending Freedom. We had the honor of serving as co-counsel alongside Idaho and West Virginia in defense of their laws protecting women's sports. And we also intervened on behalf of the athletes that you just saw, Maddie Kenyon, Mary Kate Marshall, and Lainey Armstead, to ensure that their rights and the rights of girls nationwide are protected. And just, a side note here, even as trans activists are trying to throw these women out of their own sports and to take away their rights, you can hear that happening here today too. As soon as they tried to be at the microphone, the music started on the other side. They don't want these girls to be able to speak. They want to just erase them from society. Women deserve an equal opportunity for fairness and safety. Today, Idaho and West Virginia asked the Supreme Court to allow states to protect women's sports by affirming a basic truth. Women and men are biologically different. Yet today, the ACLU asked the court to make it impossible to define sex accurately. Identity does not determine your sex, and laws that distinguish between the sexes do not violate federal law when biological differences matter, like on the playing field and in the locker room. No drug can make a man into a woman. Puberty blockers and testosterone suppression do not erase the physical advantages males have over females. All athletes can compete, but they must do so on a level playing field. Now, you heard today that no one is being harmed by this. Justice Kavanaugh said that's not correct. Sports is a zero-sum game. Someone has to win, someone has to lose. In West Virginia, BPJ defeated more than 400 girls over 1,000 times, winning 57 medals, medals that should have gone to female athletes. That's the real-world cost of ignoring biological reality. Over the last 50 years, under Title IX, women have made historic gains in rights and opportunity. Athletics teaches leadership, grit, discipline, teamwork, and so much more. 94% of women in the C-suite played sports, and we will not allow men to take roster spots, scholarships, and championships away from women. That's not progress. No girl should be sidelined in her own sport. No girl should be taught that safety is something she must surrender. Every girl deserves a real chance to compete and to win. Thank you. We're happy for your questions now. I can take the legal questions. The AGs are here as well. Yeah, questions.
How do you respond to the assertion today that in those cases where there's not a biological difference, based upon testing and other things, how do you account for that? And also, can you talk about why the laws are discriminatory in that they target trans women but also not trans men? What's the difference there?
Well, first, we categorically reject that there's no advantage. If you look at the Olympic race with Leah Thomas, Thomas suppressed testosterone for more than 2 years, and yet that didn't make a difference. He won a gold medal in the 500 meters and beat 2 former Olympians because the diminution in his athletic ability from testosterone wasn't enough to overcome the 9% gap between men and women in that sport, and that's true across all the sports. As far as the discrimination point, there isn't any discrimination when you distinguish based on biology, and if someone wants to challenge the example of girls being able to play in boys' sports but not vice versa, they're able to do that. But that's not what this case is about. This is about making sure that women like these have the opportunity to compete and win in their own sports.
What's your reaction to Joshua Block saying sex should not be defined?
That's completely bizarre. I don't know how you can decide a case interpreting sex under Title IX and under the Equal Protection Clause by not defining sex. Sex, when Title IX was passed, meant biological sex. The entire statute is written with biological distinctions. It even refers to each of the sexes. I don't know how the court can do that. And it says a lot that he felt and the ACLU felt they had to tell the court not to define sex in order for them to survive this case.
I heard you mention Justice Kavanaugh's comments there. Are you feeling confident that they would be persuaded by your arguments?
Well, we definitely think they heard our arguments, and I heard a lot of things that I was really encouraged about today. You heard Justice Sotomayor basically come out and say that she thinks that under the Title IX regulations that the West Virginia and Idaho laws are valid. That's an amazing accomplishment today. In addition, you heard Justice Kavanaugh talking about the zero-sum game, how it denies girls the right to compete and the right to win when we allow boys in their space. You heard Chief Justice Roberts say that this case is very different than Gorsuch, because when you're talking about sex distinctions, as in these sports laws, that is not discriminating against the LGBT community. So we heard a lot that we're thankful to hear today, and we hope that the court will uphold the right that girls can compete in their own sports fairly and safely. Other questions?
Where did you find out about the evidence about Lindsay Hecox not being able to graduate in May?
Boise State University is the university that Hecox attends. It's a client of Idaho. We asked, and the university confirmed that's unlikely to happen this spring.
What does it say that they tried to say that she would graduate in May?
Well, it just shows that throughout the case that Hecox has flipped back and forth with affidavits and statements to the court, and that's why the court should be very skeptical of the mootness argument in that case. They should decide it.
Barbara Ehart, who authored this legislation, said that even when she was writing it with help from the ABF, that she expected this case to come to the Supreme Court. So the question is this all a manufactured affair? Is this the goal from the very beginning for us all to be here in a theater that was designed from the very beginning?
This was not manufactured, because from the beginning the concern was male athletes across the country identifying as women, many who had suppressed their testosterone, were winning gold medals in track and other events across the country. In addition to that, you had terrible injuries in women's volleyball games. Women were being concussed by male players. In women's basketball, there were women who were being driven off the court with injuries because of male athletes. In mixed martial arts, you had a woman who had her orbital bone broken because of a male athlete who identified as women. This was a response to real problems and refusing to recognize the biological distinctions that are inherent in athletic competition. There is nothing staged about this.
We have time for one more question.
There was some discussion about whether the issue should be left to the states or a national approach. Do you guys have any kind of position on whether state by state, or would you favor a national approach?
Well, we think that eventually Title IX will establish through additional litigation that it is a national approach. And you heard some of that today from some of the advocates, that under the regulations, states have two choices. They can have a co-ed team or they can have sex-based teams. When you have sex-based teams, but then you allow male to compete on the women's teams, that violates Title IX too. This is a solution or a problem that needs a national solution, because it can't be that boys should be allowed to be female athletes in California and Massachusetts because they refuse to recognize biological distinctions while they're protected in 27 other states. Eventually there will have to be a national solution to taking away women's opportunities.
Thank you guys so much for coming today. No, thank you.
You heard from them.
Great job. I guess we leave.
Alright, guys. Stand in front of everyone. Good job. Get it.
Hello, everybody. This is a huge moment. Thank you for having me here. Sorry, I might have a hoarse voice. I'll do my best. If you can hear me, if you have the transfers, and can you scream for me?
All right.
Yep.
Do you want to come? Yeah. Ready? All right. Should we start? Hi, everyone. My name is Josh Block. I'm a senior counsel for the ACLU's LGBTQ project. I'm counsel for both the BPJ and Hecox case, and I gave oral argument on behalf of Becky in the BPJ case. And we have Becky and her mom Heather here with us. They were in the courtroom together. And I think today we had a chance to tell the Supreme Court the reality of what it's like to be a girl like Becky, who just wants to be able to play on a team with her friends and have fun. And we're hopeful that the court heard our message, and we're very grateful for all the support that has been shown for Becky over the past week. I think it's not easy for anyone to be a kid, and especially not easy to be a trans kid. And if it weren't for people like Becky and her mom, I think we'd all be in a very worse place right now. You should introduce yourself. Yeah.
Hi, I'm Kathleen Hartnett, partner at Cooley Law Firm, and I was co-counsel in both cases. I argued today on behalf of Lindsay Hecox. I just want to say I'm proud to stand with this group and this amazing client and mother, and so many people that made this possible to tell the story of what's going on here. I think I was particularly proud today to be able to make sure that the court understood the serious history of discrimination the transgender community has faced, and I'm just so proud to stand by all of these colleagues as we try to help bring the truth to the debate and also just bring some justice here in the court. Thank you.
Hi, everyone. I'm Chase Strangio. I am co-counsel along with Kathleen and Josh, and I'm honored to be here representing BPJ and Lindsay Hecox before the Supreme Court. And the only thing I want to add is that in this moment, in so many halls of power, it feels like people are debating whether or not transgender people exist, whether or not we deserve protections under our Constitution and our civil rights statutes. And today in the Supreme Court, we were able to remind the 9 justices that we do exist, that we deserve protections just like everybody else, and that there has been a history of discrimination against us that warrants the court to take a closer look at the type of government targeting that we've seen over and over again from states and now from the federal government. Thank you.
Good afternoon, everyone. My name is Karen Lowy. I am Senior Counsel and Director of Constitutional Law Practice at Lambda Legal, and I am so proud to have stood with my colleagues in representing BPJ and her mom. Today, we had a chance to explain to the court what it really means in concrete terms to deny a kid the opportunity to access all of the things we want our kids to be able to access as they grow and become fully realized adults simply because of who they are, simply because they are transgender. That equal opportunity for our kids to grow and thrive is what our laws and Constitution demand, and that is what we are all here to fight for and will continue to fight for. And we are grateful for the opportunity to make that case to the court today.
Thank you very much.
Kevin Jennings, I'm the CEO of Lambda Legal. We were proud to be co-counsel in Becky's case. What this is about is something I learned as a high school teacher 40 years ago. Every kid has a right to play. Every kid has a right to belong. Every kid has a right to be treated equally. Becky Pepper Jackson is an American hero because she stood up for millions of other kids today and said, we belong, we matter, we are equal. Thank you, Becky.
Thank you very much. Question. Josh, what is your definition of sex?
I don't think that's what's at issue in this case. What's at issue in this case is fair treatment for all kids. Sorry. I was just saying I don't think that's what is at issue in this case. What's at issue in this case is fair treatment for all people, including cis people and trans people. And that's what we're here to talk about today.
Why do you think this is confined in this case?
Quick question for you.
Congratulations, we have truth and justice on our side, even if the other side insists that sex isn't real, that if it's real, it's less important than people's made-up gender identities, or that people can change sex. My name is Carrie Dempsey.
We're going to also have the fabulous organizer, public organizer, come up one more time.
From 2021 to 2024, and as a member of the board of directors of the Women's Liberation Front from 2016 to 2020. I'm a leftist radical feminist and has been a registered Democrat since 1990, except for a few years I spent as a registered Green before re-registering in order to vote in the Democratic presidential primary in 2008. If you like, I'm a
Here's something. Give me what you got. Make it hot. If you're
ready,
you wait for it. You want to get me to say
and other leftists have been fighting back against the lies of trans. The reason is that most mainstream legacy media outlets consistently, persistently, and insistently ignore the truth. In 1979, a lesbian radical feminist professor named Janice Raymond published a book titled The Transsexual Empire, essentially predicting everything that was to come. He republished it in 1994 with a new introduction about the emergence of a very dangerous word, transgender. People didn't listen to her then, and here we are now. In 2014, a journalist named Michelle Goldberg published an article in The New Yorker titled What is a Woman? The Dispute Between Radical Feminism and Transgenderism. That was 2014. In it, she recounts an event in 1973 where a radical feminist named Robin Morgan said that she refused to refer to any man as she. It was in 2014, 8 years before 2022, that feminists were calling on people to confront the question, what is a woman? Feminists have been at this for a long time. We're just ignored. If people have listened to us over the past several decades, we might not be here. WOKE was founded in 2013 as an unapologetically radical feminist organization. As Martha said, its mission is to restore, protect, and advance the rights of women and girls as a sex class, equal opportunity, policy advocacy, public education. WOKE challenged the Obama administration over its flatline diet. WCI was launched in 2019
came all the way from West Virginia. Like, baby, there's so many trans, queer, gender non-conforming, queer, LGBTQ youth across the country trying to play sports, to play music, to study like any other youth and children. And so we're standing in for them. So big thanks for coming out here on behalf of ACLU, Lambda Legal, Trans Law Center, GSA Network, but every single one of you get all over from many states. We're very grateful for you, for standing for our trans youth, for our queer youth, and our LGBTQ youth, and for all children that they all deserve to have the same opportunity. We're grateful, big applause for all the volunteers.
It's another thing entirely to stand up to your own side.
Is here. We're very grateful for you all. Please have safe travels back home and bring this fire to you. What's there, and you have equal opportunity.
In 2019, I was proud to stand with many of you on these very steps during a rally in a case that would eventually become bus stop versus Clayton County. I was proud to come to that rally with my friend Doreen Denny from Concerned Women for America.
Thank you so much
In
for coming.
closing,
We're very grateful.
I would just say that the global feminist fight against sexist, homophobic, authoritarian nonsense that is gender identity has all been documented in the 20th century book I published called The Reckoning, how the Democrats and the left destroyed women in Europe. Women must always be able to call a man a man. We must be able to point out and acknowledge a man's sex. An average man can kill an average woman with his bare hands. He cannot be granted the right to hide his sex from her, not in local rooms and not in sports. People who find their way to this movement often assume there's a reasonable middle way. I'm here to tell you there isn't. Mad respect and solidarity to every member of the movement to protect the sex-based rights of women and girls, which includes everyone standing here today. To those who have recently found their way to it, welcome to the fight. Stay rooted and true. Encourage CEOs, even and big. Thank you.
Please go to Gender Liberation IG, Instagram, for a follow-up event. Thank you very much. Have a wonderful day.
Tell our friends we're out here wondering whether women's sports are legal. My name is May Mailman, and I'm the director of the Independent Women's Law Center. We are the legal arm of the Independent Women's Forum, an organization that uses our voice, the voices of women, to shape the most important movements and issues of the day. For the past several years, that issue has been the existence of women. This past year, I also served as the senior policy strategist in the Trump White House. One of the big reasons I took the job, besides the honor of serving a great president, is to ensure that better government rights and many long.
Can I pull your mic for you? What's that? Oh, you got to stand right. Yeah. More? Yes. Oh, you're not? I'm sorry. It's okay. I'll just lay it in. Should I just clamp it back on your thing?
No,
okay.
I didn't have the spacer in here.
Oh, okay. They're done with pressers, though. There's no more people coming out. Okay, cool. Cool. Yeah, I got you.
Is a particularly obvious manifestation of what happens when you present male and female are fluid. So is a manifestation of males abusing women in women's prisons, and so is a manifestation of men violating the privacy of women in women's sorority homes.
Thanks, man. See you on the next one.
Thank you so much.
Come back up here, man.
our desire and need for protection and the history of our existence in this country today in the court. And one thing as an observation, having been here before, is that the justices feel your presence. But more importantly, we feel your presence. And our clients feel your presence. So thank you for traveling to West Virginia from North Carolina, for staying out here for hours and hours. We feel it. We are so grateful. And here's something to remember. Amidst all the screaming and all the noise, we are never going to stop fighting for you and for your children and for your loved ones. Because we have been part of a century-long project to ensure that people cannot insist upon smallness being a limit to the expansive freedom that we promise. So thank you for being here. Thank you for continuing to be a light to so many. We love you so much, and we're never going to stop fighting for you.
Just as we are today, to protect women's dignity. And women's dignity means no men and women's sports.
All right, folks, and that does conclude our program. And folks, if you could depart to the church, if you like to prefer little groups, if you want to women also, thank you. We're trying to figure that all out. We want everyone to be safe. Everyone look out for each other. Thank you all for coming out. Thank you to continue to show up for each other every single day. And I will see you all until next time. If it's not today, we still have a decision. We got a lot of things.
My name is Nicole Neely, and I'm the president and founder of Defending Education.
You all be safe. Thank you for coming out.
Our children are being told that we might not love them, that they're part of one body, and that we should keep secrets from mom and dad. It's difficult to think of a more destabilizing idea than to plant the concept in a child's head, and it is a betrayal to do that to a family behind their back using their tax dollars.
Are they taking
Millions of dollars have been spent on gender, constituents. Tomorrow, we will all fight on, but I am confident that together we will prevail. Thank you.
Those two moments in history, and I would not be here today. I use those victories as an advocate for girls and women in sports. And let me tell you, Title IX has faced at least 20 threats in Congress, in the Department of Ed, in litigation after litigation. This is the threat to Title IX. I hate to tell you, it's not new. Swimmers and track and field athletes know the difference between men and women. Unlike other sports like soccer, football, and they're not head-to-head. We are in the same coach, same facilities, we go to the same teams, there's the women and then the men. There's an 11% difference. Everybody goes to coach at a certain level. We're not 11% faster.
Individual is coming up negative 4.1.
The difference in 11% is to think that I work together to be 11% faster. I promise you there is no way I could have worked a smidgen harder and been able to swim any faster. So now, finally, women's sports are having their moment. We've got Caitlin Clark, we've got Serena Williams, we've got Katie Ledecky. We're having a cultural moment. And now, the men want in. We couldn't even get men to enforce Title IX for decades. We couldn't get them to take us seriously. We had to fight for it.
They're going to make the arrest.
To get men and media to invest in us. I don't know where women's soccer would have been without Donna Deverona and her compatriots making sure that the 1999 Women's World Cup was played in the Rose Bowl. And now, women's sports aren't embarrassing anymore, and men want in. You've heard it all here, you've heard amazing speakers, but I'm here to encourage you all to take this love, I want you to take this passion and this focus on women's sports and apply it for all different types of misogyny. We will win these cases back here. Gender ideology will be defeated, but like in the UK,
who got what they wanted from their Supreme Court will need to keep working, and it's going to take a bipartisan effort. I'm really proud to be part of this bipartisan effort. The Women's Sports Policy Working Group is also. College women right now are being denied 72% of the opportunities that they should have. The enforcement on the legal rights that we currently have are not not the Department of Education.
No, but we do have people who are barred.
You're dependent on the kids to be able to do this. Women are missing out on 50% of the college scholarship dollars. I want you all to take this love, this support, and working across the aisle, bipartisan, to support us, to support women's sports. Even if you aren't an athlete, even if you don't have a kid that's in sports, we know what sports does for girls writ large. They are leaders, they do better in school, they are more likely to be in the workforce, they have healthier pregnancies, they are healthier for the rest of their lives. These are impossible to learn these skills in math class or any place else. This is another noble purpose that we are all a part of. Women's sports are life-changing. Please, keep working for women. Thank you all very much.
Alrighty, okay, we're rounding up the end, and I can't, I'm super excited for the representative. She just got out of the Supreme Court. But good afternoon, my name is Debbie Kurlitis. I am the Vice President of Moms for America. We are a national organization of about 500,000 moms working to reclaim our country, our culture for truth, family, freedom, and the Constitution. As mothers, and how many mothers do we have in the audience? A lot of moms have been speaking today, right? As mothers, our first instinct is absolutely to protect our children. That is why protecting our daughters in their sports and in their locker rooms has become one of the most urgent issues of our time. That is crazy to say, but it is so true. Across this country, moms have shown up. I've got Moms for Liberty here too. I just think about that. So many of us have been in this fight. We've shown up. We've written letters. We've testified at school board meetings. We've championed legislation, and we've stood in front of cameras like this all across the country because our girls deserve safe and fair sports. Never, never underestimate the mother who's protecting her child. She will outfight fear, she will outlast danger, and she will outlove the world. And you surely do not mess with Mama Bear. You do not mess with Mama Bear, and you do not put her cubs in harm's way. So as moms, we fight hard, we know that. We demand answers, but we cannot do this alone. That is why we are so thankful to our brave female athletes that have been involved in these cases today. Thank you to those girls. Thank you, ladies, for being bold. And thank you to our legislators who have made this a priority. I do want to thank West Virginia State Senator Petitioner for the sponsor of Save the Women's Sports Act, and all those who voted and championed that bill. Thank you, West Virginia, for standing up for our daughters. And we also defend our daughters for dear She is a true friend. We love this battle with her. Can't do it without the moms. Can't do it without the dads. Can't do it without without the legislators, we can't do without the athletes, and we cannot do it without legal defense. Today, we look to the Supreme Court. We're asking them to restore fairness, protect women's sports, not just in Idaho and West Virginia, but all across America. America is the land of opportunity and dreams, a place where our girls should be free to learn, compete, grow one day of their own. The biological differences between men and women are real. They're factual and they're intentional by our Creator. Mothers are not confused about what it means to be female. We get it. The moms get it, right? We live it as mothers. We give it. We raise daughters with dreams, purpose, and strength. And we will not allow these daughters to ever decide. To be silent.
Hey, can we get on the sidewalk, y'all, please?
I got him to pull up the footage, so.
It's about women and truth. It's about mothers standing between their daughters in harm's way. History shows this clearly. When mothers rise, nations change. And mothers are rising. We will protect our girls, and we will not stop fighting. Thank you all. God bless. God bless America and our girls.
No, but I was so I was there. I didn't have the animal, but I was so amazed.
I gotta go. I'm gonna go tell the lieutenant thank you.
All right,
you guys. Those of you who are left, give me your last bit of attention, because I am wrapping up.
The guy in the lab coat, there's a guy in the lab coat.
Hey, State Representative Barbara Ehart, the Division I women's basketball player and a 15-year Division I women's basketball coach. That is what set the impetus for coming up with this legislation. In 2018, when I sat in war, our Connecticut gals had their opportunities stolen by boys. Boys, if you're not the boys team, there was no reason they're trying to do opportunities here, taking trophies and wins. No confusion. I remember walking around my home thinking, somebody needs to do something about this. Why doesn't somebody help? And it came very clearly, Barbara, you're a state representative. You're a former women's basketball coach. You're a collegiate athlete. You need to do something about it. And so with 2 years in preparation, we are finally able to bring this legislation, ultimately with the help of Alliance Defending Freedom, to whom I am so grateful. So grateful, ADF. You are an amazing organization. But I just wanted to leave with you a couple things to think about. First, do we have any athletes left out there? You didn't get to come up, but do we have any female athletes? We've got one right there. I love it. How old are you? 5. A 5-year-old. One of the reasons we're doing it so our 5-year-olds don't have their opportunities taken away by a boy. If you guys were with me in some of my testimony, you would have heard a story that went like this. And I wish I could have shared this with the justices. I wish they could have heard me say this.